This is a private firm. Well, Section 23 deals with private firm. Company includes partnership.
In the written statement, written argument, you have given all this.
Yes, and also I have given a judgment, my lord, in my case, my lord, delivered by my Lord Justice Panigrahi, dealing with all those aspects.
That's fine.
And passing the.
You underline those things and give me.
Yes.
Oh, no, don't worry.
Madam.
Pardon to make a mention.
Don't go by what.
No, I'm saying. No, because my lord, in the live streaming, the party have seen this. They have said, my lord, I have said it is different. So you have to make a mention. Otherwise, my lord, I will not bother you.
I may pardon to mention, my lord. In basis of compromise, I have here LMC 1721 is admitted and today posted for inadvertently that has not come. Lordship
Settlement
matter, my lord.
Probably it's 150 matters today.
My lord, kindly
Just try it, accommodate in 21st.
I may pardon to mention, your lordship.
He'll give it in before the vacation.
I may pardon to mention, your lordship, the NBW has been issued against the husband, your lordship. So the matter is just listed before 2 days. I pray for Passover, your lordship. So matter posted to.
See, I am not going to give Passover even today.
Only I small pray, your lordship. This is a 498 case. Divorce has been already allowed. So my prayer before, your lordship, I will take the notice only.
NBW.
Cancel
is not NBW.
Yes.
Give it.
Monday, your lordship.
I may be pardoned to make a mention, my lord. I may be pardoned. My lord, item number 131. My lord, I am the opposite party in this case, and there is a stay since 2022. And I have filed a petition for vacation of such stay. It got listed twice earlier, but did not reach. So my humble prayer that it may be taken up at 2 p.m. 2 p.m.
Your prayer is.
No, my lord, because of the stay, I am suffering. The wife.
But you have to see who is appearing for other side.
The other side took adjournment on the last occasion.
Let us see by lunch how much we can, read.
Your lordship.
And tell me at 2 o'clock.
Will be highly obliged.
I may pardon, your lordship. Another matter, compromise, your lordship. Already matter has been settled between the parties, your lordship.
And within these 3 days, I don't think
On Monday or Tuesday, small matter.
difficult.
Is highly obliged.
Please give it. Yes. And highlight those judgment and all, the paragraphs.
My lord, 2 years conviction, vigilance case. And my lord, that petitioners on interim bail. Interim bail period will be expired, my lord. I pray for tomorrow.
Not tomorrow, Monday.
Oh, bless you, Lord.
My lord, item number 63. I pray for after vacation.
Page wise will just.
Page 1,
Sorry.
item 1 to 7.
And memos, please give the memos. We'll see. All memos, please give.
Page 1, item 1 to 7.
Yes.
Page 2, item 8 to 19.
item 15. I will remove the defect in the can it be taken up on Monday?
Council for the petition seek the adjournment to your defect. Point over the day. Yes.
Page 3, item 20 to 28. Page 4, item 29 to 40. Page 5, item 41 to 44.
Pardon, my lord. Item 42, my lord. Both parties are coming, my lord. Take at 2 p.m., my lord.
Offense?
Both parties are compromised, my lord.
Offense?
482.
482 is the offense.
Offense. 98, my lord.
498.
So both parties are coming, my lord. 2 p.m., my lord. Item 42.
Page 6, item 45 to 57.
Item 56 and 57, my lord. On behalf of Mr. Satvati. Someone has passed away. Yes, tomorrow.
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 No question. Before vacation, don't ask anything.
It's an emergency. Someone has passed away.
Maybe it's all right.
So for I pray for tomorrow, madam.
150 matters tomorrow. I don't know 190 or 200 matters. Is it possible?
Okay.
What is the fun in listing if I can't take it up?
It's an emergency. You have to process.
That's right. You have emergency. I'm accommodating. Yes.
Page 7, item 58 to 72.
My lord, item number 63. I pray for after vacation.
63.
Yes. Obliged.
Page 8, item 73 to 88. Page 9, item 89 to 103. Page 10, item 104 to 115.
199 and 113, my lord. Kindly taken up after that.
Yes. 9 and 30.
Oblige.
Page 11, item 116 to 127. Page 12, item 128 to 133. Page 13, item 134 and 135. Page 15, item 136 to 139. Page 16, item 140 to 150.
My lord, item number 154, kindly after vacation, interim order to continue.
Let's say one.
The other side.
Other side, notice was issued and interim order was granted. Nobody has filed any Wakatnama in this matter.
File requisites and all.
Yes, yes, I filed in time. It's filed in 18th after your lordship's order.
Let's say item one.
Interim order to
You
continue.
take the advantage of interim order because of.
No. It's a my lord, because in the 97 petition, the custody of the child has been given to the father, who is a deaf and dumb. Therefore, your lordship has
Okay.
granted this.
Okay. Yes.
Let's go item 147 and 139 kindly taken up after vaccine.
Yes.
That may be fixed, my lord, in that.
In all matters, date will be fixed.
My,
141 item, I am for the opposite party, looking for after vacation. Oblige.
I beg to pardon, my lord. Item number 132. Yesterday, this matter was listed. Two matters has not been come.
132.
Yes, my lord. You compromise. So today, yesterday, your lordship told that this matter will taken up first.
Yes.
So I told lordship, both are the present. Your
I'll
lord.
take it up.
Yes, thank you. Oblige, my lord.
Pardon, my lord. Pardon, my lord. Item 12 permitted to withdraw, my lord.
Give the memo.
Pardon, my lord, after item 47 kindly taken over after vaccine.
47 also. Yes.
Oblige.
132.
My lord. My lord.
47, 41, 47.
Who was not there yesterday?
Pardon, my lord.
There is a case, counter case. Yesterday, the petitioners, connected case CRLMC 1846,
How many matters? Four.
Four matters.
four matters,
Actually, two cases, madam.
two cases
In case two accused persons, for that, four cases.
arising out of one PS case, three cases filed.
First, you tell me the FIRs. Huh?
FIR,
First matter FIR.
first lordship 2927 and 1846.
Or good one FIR.
Yes, my lord.
2927, 1846 and 354 is one FIR.
354. Write down. 2927, 1846 and
354,
354.
my lord.
ये तीनटा गुट्टी सब नहीं जाओ, ठीक है?
Yes.
They are the accused person. Three accused persons.
Three accused persons.
Right. Petitioners are you. Then I'll. Who are they? All them. 376. What are they? Rajiv Kumar Agarwal.
Rajiv Agrawal,
Abhishek Agarwal
Urmas.
Abhishek Agrawal.
and Rajesh Agarwal.
Both cases.
Three cases.
Three cases, my
All
lord.
total four cases, madam.
But three cases I'm taking right now pertaining to one FIR.
Yes.
Yes, my lord.
No, madam.
Yes, madam. 2927, 1846 and 354 arising out of one FIR.
2927.
One
That is 46.
46 and 354.
354.
354 arising out of one FIR.
Okay. Three accused.
My lord.
Three accused, same complainant.
Same complaint.
Okay. First, these three, you check it up. Purnamasi Malik,
Yes, my lord. I am for the.
where is he? Yes. Right on. At the instance of opposite party number 2, FIR number so and so, under section so and so came to be reached against the petitioners. Petitioners, in all the three petitioners. The allegation in the file. Okay. Charge sheet was filed.
Charge sheet on filed on series now the other accused under section 4 and 5 of Immoral Traffic Act.
after investigation, charge sheet was filed on
30th 9
30th 9
2024.
2024. uh,
41.
21
Under section
Uh,
4 and 5 of criminal
for
trafficking.
alleged offence under section 4 and 5 of immoral trafficking act.
And London magistrate took cognizance also same offences.
And-
That's 25.
And subsequently on 22/10/2021, the magistrate had taken cognizance for the alleged offence, alleged offences. When the matter stood thus, the parties have settled that issue. The opposite settled their dispute. And where is that affidavit? Yes.
Opposite party number 2 file individual.
Opposite party number 2 had filed an affidavit dated 14/2/2023, inter alia stating that
This is paragraph 3 plus it. Paragraph 2 and 3 and 4.
inter alia stating as under para 3, 4 and 5. 3, 4, 5. 3, 4, 5. ने यो affidavit अच्छी थी, ठीक है? And the opposite party number 2 being represented by their opposite party number 2 is present in the opposite party number 2 and all the petitioners are present in the court, represented by their respective counsel and identified by them. They have also filed self-attested copies of the of their Aadhaar card to establish their identity, which are taken under court. What is the terms of settlement?
Terms of settlement, Miller, there's a case and a counter case. Now interference of they have both decided to withdraw all the cases. And
what is the counter case? Who has filed the counter?
the petitioner in CRLMC number 1846 of 2020. Abhishek Agarwal.
He is the husband.
No.
Well, actually, both are the business partners.
It is stated and apparently petitioner in which case?
In CRLMC number 1846 of 2022.
CRLMC 1 or Abhishek
Agarwal.
Abhishek Agarwal has filed a counter case against the opposite party number 2.
That is on good case number 446 of 2021.
Being
on good case number 446 of 2021.
Under section?
Under section 341, 294, 323, 679, 389, 534.
That's correct. The petitioners and opposite parties have settled the entire dispute, and in order to pass the cross case, a separate which is that petition in order to pass the cross FIR.
That is the CRLMC number
CRLMC 351 of 2023 has also been filed, which is listed today. Listed today. Mr. Ragada appears for the state and submits that all the both the FIRs has been filed between the parties, filed against each other by the parties, and due to the misunderstanding in the business being carried out by them in partnership. Since the parties have settled their dispute, there is no legal impediment causing the FIR, taking into consideration the judgment of the report is dancing and and out in it is 351. Next out is 351, and though at the instance of petitioner, sorry, at the instance of opposite party number 2, FIR has been raised. Who is Rajesh Vishwal? Rajesh. Opposite party number at the instance of how many is there?
Four,
my lord.
Accused lordship 3. Father, son, and Rajesh Vishwal.
Father, son, and
Rajesh Vishwal, 3 accused persons.
At the instance of opposite party number 2, FIR number shown came to reach 351. This is a cross case being filed by the opposite party against the petitioner. In view of the judgment, in view of the order passed by this court on the court today, in bed, eligible, so and so bed, the FIR number so and so, eight is FIR number so and so, was. Yes. All four cases.
Obligement.
Yes.
Item 1.
Pardon, my lord. Item 21, I received a copy on 14th.
How are you mentioning in between?
Deeply obliged.
Sorry, 21.
Wait.
Item 1.
Yes. Just see what is this matter.
My lord. Absolutely, my lord. This matter, my lord, disposable, anticipatable file, my lord. By Narayan Sundaram, my lord. With case, that is my lord, with case. In that case, my lord, the present petition filed by the same petitioner, my lord,
Bail petition.
or cancelled prayer, my lord.
Cancellation of.
Petitioner cancelled prayer, my lord. Petitioner. It is therefore appealed and Orissa would be graciously free to cancel the aforesaid bail petition.
By invoking its extra. What is this petition?
Same look, answered by same look, filing the case cancel.
In this petition, the petitioner has prayed in prayer. I find the prayer and the petition is innocuous one, and devoid of merit. Therefore, I'm not inclined to entertain hence dismiss. Yes.
Item 3.
नहीं दीटा बेटर और तातला गुड़ा चाहिए ABPL हाँ
At a concern court को anticipated.
ABPL 19962 of 2006 leaked it before the assigned bench.
Pending
Assigned bench after approval of the honorable chief justice.
Lordship, may I please?
I don't know one, both the parties not appearment of the
Non-APS for party.
Lordship, item 3, may I please?
2.
3.
2 will be taken later. Non-appearment both the parties is except state, my lord. Non-appearment both the parties are except state, my lord. We are appearing, my lord, for the state.
हाँ नहीं वो तो state sacrifice मित्र वाला किसी Yes.
My item 3, my lord. Petitioner's younger brother lost an affair. The petitioner's younger brother's wife lost an affair. Out of civil dispute, this affair has been lost, stating that the offense is 341, 294, 323, 350.
What are you asking here?
Asking, my lord, in this case, younger brother's wife lost affair against brother-in-law, sister-in-law, बड़ा भाई, देढ़सुर जा, and तो छोटो पिला छुआ, जो पुओ झियों को ना रे रहिला, किंतु चार्जशीट रे पुलिस पुओ झियों को काटी देइची, किंतु देढ़सुर जा petitioner 1 and 2, and आउतार जो से जो वाइफ रो आउतार जो ने रही ची तार जो ता कौन को
ଆପଣ ଜଣା ଜାଣିଥିବେ ନା କଣ କହିବେ କି how we know that.
ସାନ ଭାଇ petitioner ସାନ ଭାଇ ଜଣ ଅଛନ୍ତି.
ଛାଡ଼ନ୍ତୁ what do you want exactly?
ମାନେ 319 petition has been filed by the prosecution. ମାନେ ଚାକିରି କରିଛନ୍ତି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ସର୍ଭିସ.
No order passed, my lord.
Can you prevent?
No
They have a right
pass.
to file application.
No order has been passed. For that, they have not filed any order, my lord.
Can I pass an injunction order? Don't file this application, that application. They file application.
If order
Don't
passed, if the order passed, then only it came.
Though, my lord, they are
Only they have moved an application.
Application.
my lord, since 21. Since 21, it is
Right.
given.
That's good that court has not passed any order.
My lord, only they are threatening. Service करजो एमती कर देव सिंपल.
Order ta hele tum jack challenge karibe.
though my lord, out of family dispute, my lord, Nothing.
Let the counsel for the petitioner seek to withdraw the petition to argue before the, agitate the grievances before the court below, with the liberty the petition. Yes.
Okay.
Item 4.
I am on behalf of Kures Prasad Das. Kindly 1 week time because ये defect in
Okay, adjourn. Next.
Item 5.
5. क्या defect है क्या?
Different. One defect is there, madam.
Registry has pointed out a defect which has not been cured. 1 week time is granted to petitioner to cure the defect, please estimate. After, yes.
Item 6.
Item 6, may I please, my lords. My lord, this is an application for release of vehicle, my lord, challenging the order dated, which is at Annexure 3, my lord.
Yes.
Order dated 1/12/2022. My lord, although I got to know that similar matter, this honorable court has passed a judgment, but I could not go through that judgment. Relying on Sundarbhai Ambalal Desai, my lord, I pray for release.
After vacation.
No.
After vacation.
No, my lord, I pray that the matter may be disposed of for release of the vehicle.
Release a vehicle, you have to make out a case of release.
My lord, I can make out a case, my lord. My lord, primarily I'm not accused in that.
What is the offense?
My lord, offense is under
Yes, Mr. Ragada, 394.
307.
Subsequently convert 395, madam.
395 to convertation.
Docket case, my lord. What happened in this case, my lord? Actually, vehicle has not been released in favor of the petitioner because, my lord, therein does not the seizure list does not disclose the engine number, chassis number of the vehicle. And another thing, my lord, the vehicle in question, my lord, the accused stated in statement that he taken the vehicle from one of the co-accused Arun Kumar Sahu, my lord.
Who are you?
My lord, I'm the owner of the vehicle, my lord. I'm not an accused in that case. My lord, owner of the vehicle, my lord.
Owner, my lord, with regards to owner, my lord, that is, my lord,
I have given to this registration.
No chassis number, engine number is available, my lord.
How the court will ascertain that?
My lord, I have given the registration certificate. That is an Annexure 2 series, my lord. The lordship may just verify that.
For that reason, my lord.
69 number page.
Page
69 and 70.
Wait, 1 minute.
I've specifically given, my lord.
This is Bajaj Pulsar.
Pulsar 220.
Number?
Pulsar.
Registration number OR02 BW
BW 9986. My lord, yes.
Sir, see, admit korsanti.
My lord, kindly come to running page number 72. The Noyapalli, fourth last line. The Noyapalli IC seized Bajaj Pulsar 220 DTS FT motorcycle bearing a registration number OR02 BD 9986. That is my vehicle, my lord. And I have specifically mentioned that one of the co-accused has taken my vehicle, but the reasoning it has stated that I have not lodged an FIR, my lord. He has taken for some personal use, my lord. He has not stolen, my lord. That was my contention.
In connection with this crime, my lord. 395.
My lord, this
And the chassis number, vehicle number, the doubt, my lord, and that happened, my lord, the ownership with your
You
ownership.
have filed an application where you bereft of any particulars. That's what it is rejected. Just see.
Then with that observation, your
you
lordship,
file
your lordship,
the petitioner moved an application under section 457 CRPC for release
451, my lord.
351 CRPC for the purpose of release of the vehicle seized in connection to the FIR number so and so so and so. Petitioner is not an accused in the FIR. It appears the vehicle was used for commission of the offence. The application moved by the petitioner has been rejected on the ground that the application is bereft of any particulars, bereft of particulars, and the application was cryptic one. Mr. Mahapatra, learned counsel for the petitioner submits that he liberty may be granted to him to move a press application with material particulars.
With registration
material
certificate.
particulars, and the impugn order may be set aside. Taking into consideration the aforementioned, the impugn order dated MP notated 1/12/2022, passed in CMC, case number 138 of 2022, passed by
Learned fifth additional district and
passed by
session judge Bhubaneswar. Fifth additional.
District session judge Bhubaneswar
In CMC.
is quashed, and the petitioner is given liberty to move a fresh application. If such application is moved, the same shall be considered on its merit without being influenced by the observation.
Taking note of the law laid down in Sundar Bhai Ambalal Desai.
Without being taking note of the
Sundar Bhai
report in
my lord, Sundar Bhai Ambalal Desai judgment.
taking note of the settled principle of law by the Honorable Supreme. Yes.
In that judgment.
Next.
Oblation.
7.
Yes, sir. What is this defect also you? Anyway.
Copy note, sir, my lord.
Copy note.
କପି କାହାକୁ ଦବୁ?
ଆମକୁ ଲେଖା ଆମକୁ ଦେଇନାହାନ୍ତି। ଅଛି।
ନାଇଁ ଆପଣ କପି ପାଟି କରନି ଆପଣଙ୍କୁ।
ଆମକୁ
Any complaint? Yes, anyway.
My lord, 138. Company has not been made a party.
Okay. Where is the complaint?
Complaint, your lordship, page 6.
Show me in the Jayama Santoshima Infrastructure Private Limited.
Sir,
Authorized person.
check Tasarala, page 11.
11.
My lord.
Page 11.
Joy Sun
किए देखिए
Infrastructure Private Limited.
किए दुनिया किए पढ़ी परिवेनी अपन
Sir, ହଁ ସେଟା ଗୋଟେ କଣ ନୂଆ ପ୍ରକାର check?
Huh?
Lordship is saying, talking about the check.
no complaint you show me issued by the company.
Sibo Sankar Joy Santoshima Infrastructure Private Limited.
Which paragraph?
Paragraph B, page 7.
Yes.
Sibo Shakti Security Service is outstanding against.
Not the paragraph, sir. Complaint.
Complaint sir paragraph पढ़ुछु परा. Messr Sibo Shakti Security Service presented the said check on dated of Sibo Shakti such and such. Your lordship is asking for who had issued.
Show me that from the complaint that the company has issued check.
Check I am showing your lordship.
Check from the complaint.
On 16/10/2015, when the check was issued by the authorized signatory, the director of Santoshima Infrastructure Private Limited.
A good company, Mass Santosh. Right. Mr. Strategy, senior counsel for the petitioner, submits that the petitioner has been arraigned and accused for an offense under section 138 without including the company. From the perusal of the complaint indicates that the subject check was issued by the authorized representative.
Authorized
Representative
signatory
of Messrs.
Joy
Santoshi Ma Infrastructure Private Limited. The petitioner is the authorized representative. Huh?
My lord.
Petitioner is one of the directors. Therefore, Mr. Strategy submits that in the absence of including the company as a accused, director simpliciter cannot be prosecuted. Issue notice to the opposite party. In the meantime, proceeding before so and so state. Yes. Next.
Item 8. Next is item 8 and 9 paper after vacation.
Adjourn.
Item 10.
Let me please your lordship. The petitioner is aggrieved because despite overwhelming materials, no cognizance under section 307 was taken. The short fact is that while the petitioner and his
Who are you?
Yes, my lord.
Who are you?
I am the informant as well as the petitioner.
Charge sheet was filed under which provision?
Charge sheet was filed under section 341, 323, 294, 354, 506 by 34.
307
was
is
not added. Not
added.
added. Not
Then
added.
you filed protest petition.
Thereafter, I filed protest petition.
Right.
And after protest petition, the Law and Trial Court was pleased to take cognizance under sections. In addition to all these sections, the Law and Trial Court was pleased to take taken cognizance
under section 341, 294, 323, 325, 326, 354.
307 is not made out.
326 life imprisonment needs cognizance.
So we want that the 307 to be added.
Why you are so fascinated about that provision? 326 grievous hurt.
Grievous hurt.
It is that is a grievous hurt, but it is
Show
also
me the
not.
injury report. Show me the injury report.
Injury report.
Show me the injury report.
Injury report page number 31.
31.
Actually, that is a scalp injury, deep-seated scalp injury.
32, this page 32.
Page 32. I have given the photographs.
But just see 31. Simple. What to do?
Some the simple.
Nothing can be done. Right now. The petitioner is being informed. After investigation, charge sheet was filed by the police. Charge sheet was filed on. No, charge sheet was filed on 10/9/2020 for alleged offences under section 341, 323, 294, 354, 506, 634, and 324 IPC. The petitioner was not satisfied with the investigation and alleged that the police has deliberately left out a grievous offence under section 307 IPC. Therefore, he filed a protest petition and laid independent evidence. After the protest, after the evidence recorded by the informant in the protest petition, the court below, by order dated
16/5/2022.
by order dated 16/5/2000. Where is that?
The page number
44.
44. By order dated 16/5/2022, had taken cognizance for offence under section
341, 294,
294, 323, with 325, 326, 354, 506, 34 IPC. Then Constable, the petitioner has drawn my attention to the injury report and the photograph of the victim. The injury report placed on record indicates that the injury sustained by the informant, all the injuries sustained by the informant are simply limited. Since the trial court has taken cognizance for offence under section 323/326, apart from other offences, I am not inclined to interpret this petition. Hence, yes.
My lord, I may be permitted to raise all these points during the trial.
Needless to say that the informant has all the liberty to raise the points before the court below at appropriate stage. Yes.
Whatever level.
Yes.
My lordship, item number 11 may be taken after lunch.
Adjourned. Yes.
Item 13.
May I please, the lordship? May I be permitted to appear through virtual mode?
Yes.
The lordship, in the present case, the petition challenges the order dated 19/8/2023 passed by Lord and Additional Sessions of Jagasimpur, thereby rejecting his application under section 227 CRPC. The lordship, during pendency of the said petition, the trial has already commenced. Hence, my only submission, only humble submission, the trial court may be directed to expedite the trial. Lordship.
When was the FIR?
Your Lordship, 2/6/2022. 2020, Your Lordship.
2020, offense 498, you are the accused.
Yes, Your Lordship.
Right.
In the meantime, the government and PW 3 and 4 have already been examined.
Petitioner is agreed by the order dated 19/8/2023, passed by the additional sessions Jagatsinghpur in connection with the city case number 159 of 2021, whereby the application under section 227 CRPC has been rejected. Let counsel for the petitioner Adyasakti Priya, let counsel for the petitioner submits that in the meantime the trial has already progressed. Therefore, she doesn't want to press this petition, reserving her right to raise all the points before the trial court. At the same time, she submits that in view of the fact that the FIR was lodged in 2020 and the trial is proceeding trial is proceeding in snail space. Directions should be made to expedite the case. Expedite the case. Since the petitioners, since the accused persons have constitutional right of speedy trial, therefore, I expect the trial court to do well to see that the trial is disposed of as expeditiously as possible. Disposed of. Yes.
Obliged, Your
Yes.
Lordship.
14.
Visual Lordship. In this case, I am challenging the cognizance taking order of the London Trial Court at page 16.
Yes.
Order dated 11/10/2017. Initially, an FIR was 1cc case. Subsequently, an FIR was registered. I am no way connected with the case, Your Lordship. From the perusal of the 1cc case, Your Lordship, which was subsequently being the part of the FIR, but at page 11, the fact of the case.
Come to the charge sheet. What is said against you? Charge sheet.
In the charge sheet at page 25, Your Lordship, there is nothing. At page 25, Your Lordship.
You are
I am Augustino.
reading. During the investigation, we did the spot.
Examined the complainant and witness and recorded their statement. The dowry articles and the photographs of the Santosh Bishwal, all the accused persons, Keshav Bishwal, Padma Bishwal, Parsurani Dhara, Sanjeev
Statements are
Pradhan.
there, just see in the, down the line.
Milord,
Page 20.
Milord,
That is page 20, Milord.
Yes.
Page 20.
20.
Yes.
20. No,
Yes.
26.
Sorry, 30. Page 30. 30.
Yes.
The last one line.
30.
Last one line.
Yes.
Yes. ଏହି ବାହାଘରରେ ମାଇଲଟ ଏହି ବାହାଘରରେ ଶରତ ପ୍ରଧାନ ଓ
So, you have already been arrested.
But arrested and released on bail.
So, shall I stay the proceeding?
yes.
Why him here?
ତାଙ୍କ ଏଗନେଷ୍ଟ ଷ୍ଟେ ହେଇଯାଉ
Proceeding pending before the court. I have to record it.
Yes,
The petitioner is challenging the order of cognizance dated
11/10/2017.
Whereby cognizance for offense under section 498. Where is that order? 11.
My lord, at page 46, second paragraph, towards the end.
Tell me the sections.
My lord, 498A, 323, 506, 494, 406, read with section 34 of section 34 of the IPC, read with 4 of DP Act.
DP Act has been taken against Mr. Department counsel for the petitioner has taken me to the charge sheet and the statement recorded under 151 CRPC of the witness. Which witness, Mr.
My lord, all the witnesses have
All the
stated
witnesses.
ଏହି ବାହାଘର ଶରତ ପ୍ରଧାନ ଓ ଅଗସ୍ତି ଧଳ ମିଶିକରି ବିବାହ କରେଇଛନ୍ତି।
The only allegation against the present petitioner is they were instrumental in arranging the marriage,
The marriage.
between the
Second wife with the petitioner, with the main accused.
with the opposite party number with the
1 and 4.
the
1 and 4. 1 is the husband, and 4 is the lady with whom the second marriage.
one
took place.
and 4, accused number 1 and 4.
1 and 4.
Barring that, there is no other allegation. Issue notice to opposite party number 2, returnable also. In the meantime, proceeding in GR case number 287 of 2016, pending before the court of SDGM,
My lord.
Veer Maharajpur is dead qua the petitioners. Qua the petitioner only.
Only.
Otherwise, everybody will take it. Yes.
16.
Your my lord was like the previous case, my lord. My lord, accused is
Item number 16 may kindly pass over.
No passover, madam, today.
As my learned senior is in another court.
It's all right, but what to do? Let us see. He is the petitioner. You are the opposite party.
no, they have filed an application for vacation of the interim order.
Interim order.
Case is like this, my lord.
Let us-
My lord, one Mr. Behera, allegation against him is 498A. This is like second marriage. Present petitioners were witnesses in the deed. Marriage certificate, my lord, they are the witnesses. Like the previous case, my lord, they have helped the men accused for the second marriage. How can they be accused in
But
498A?
there is some SLP pending.
My lord.
SLP pending. Therefore, I state.
And my learned senior friend has filed application saying that pendency of SLP is not a bar to.
No.
As the only point is that there is no stay in the SLP.
Right, but see, why should we do something which will threaten the
That matter
petition
last
pending
petition
before Supreme Court?
solved,
to
huh?
impact the-
No order can be passed once the application is pending before the higher
We should
court.
not. We should refrain. Simply adjourn it.
wait, we have
Interim
to
order to
wait.
continue. Adjourn it.
With international, the SLP was not filed by this petitioner.
I understand that. I recorded that. The husband has filed.
By offer.
Husband has filed. I know that.
So, so far as my petitioner is concerned, this case should not be stayed. My humble submission is that.
No, husband case is pending there.
Yes,
It's 498 case.
he is not the husband.
But that's right. But let us.
Petitioners, two petitioners.
Let us wait for the outcome of the SLP. I'll simply adjourn. I'll not pass any order in your application. Application will also be pending. Simply adjourn.
And my lord, may direct them to correct the petition. They say yes, ST case number 186. It should be CT.
City case कर दियो तो जो file details कर दो.
Paragraph 7 and 8.
Adjourn. Interim order to continue. At the request.
7 and 8.
17.
17.
My humble submission for you that let my learned
I have simply adjourned interim order to continue as it is today. There is no scope. 150 matters are there. Wait.
One prayer, my lord, I am making.
Yes.
Last, my lord was pleased to adjourn a particular matter to today with regards to my lord section 33(5) of POCSO Act.
The prone to me, I am his nephew, my lord. No allegation against me or ominous allegation, my lord. Though saying
But there is allegation.
Yes, allegation.
Injured statement also, it is there that.
I pay after vacation.
I'll give you liberty. Argue that.
I have a good case, my lord.
Huh?
I have a good case.
After vacation, it will be a good case. Today you don't have. Okay. After vacation.
A date may fix.
Date.
Item 18.
Obliged.
Item 18.
Lot of defects pointed out by the registry has not been cured. 1 week time it will take to the petitioner to cure the defect. In the event defects are not cured within time, the petitions are being dismissed without reference to the court. Yes.
19.
My lord, item number 18.
You are standing, I pass the order. There are some defect, you cure the defect within 1 week. If you don't cure, then it will be dismissed automatically. Okay, you cure the defect, I have given time. Don't show PS for them. Okay.
Well, in my case, that defect will be ignored.
Huh?
In my case, 17.
Oh, you forget.
Yes, of that.
Yes. Mhm.
Item 19.
May I please, Lordship? What is the quashing the FIR, Lordship, under section 498, 306, Lordship?
Who are you?
I am the mother-in-law and sister-in-law, my lord.
Have you settled the dispute?
No, my lord.
Is there any chance of settlement?
My lord.
Huh?
My lord.
Simply
And
I
the
issue
page number, I am not present in the occurrence and the
Anyway, I will issue notice to us.
Yeah.
Tribunal dispute. Issue notice.
further proceeding.
304B. Very difficult. I simply issue notice. Let us see.
My lord, charge sheet was submitted.
5 cases.
Charge sheet was, my lord, submitted.
Why 5 cases?
Mother-in-law, sister-in-law, and brother-in-law. my lord.
Oh, 304.
No, my lord, 306, my lord.
306. How can we?
Page number 14, my lord. 498, 306, my lord.
It has to be all the. Show me the charge sheet.
Page number 14, my lord.
Just see or no.
But multiple witnesses have said that there was altercation between them. Bibadar Somadhan Hitler, there was a settlement between the parties, and thereafter this incident has occurred. Therefore, this is the case which should go to trial.
Cognizance says, how can I interfere?
No, cognizance, my lord, nahi na dega. Cognizance nahi na do.
Then wait.
All the statements are annexed at page 28
Yes, I can
onwards.
see that.
ସେ 2 ବର୍ଷ ଆগে ତାଙ୍କ ଘରେ ଥିଲେ ଆସିକି ସୁଇସାଇଡ୍ କରିଥିଲେ ଏଫଆଇଆର ଆଜ୍ଞା ଅଛି 2 ବର୍ଷ ଝିଅ ମୋର ଥିଲା ସେ ମୋ ନିଜ ଘରେ ଆଜ୍ଞା ରହୁଛି ଯୌତୁକ ଅଧିକ ନିର୍ଯାତନା ପାଇଁ ମାଇଲ
You argue all this point at the time of framing of charges. Can't be, because I can't go into every detail of the statement at all.
And my lord, 161 of the informant has not been filed.
On the 34 page, my lord, Debo Krupa, my lord, it's a 8 years old girl, my lord. Your statement there. ମୁଁ ଖାଇସାରି ମୋ ଦିଦି ଘରେ ସାନ ଭଉଣୀ ବଡ ମାଙ୍କ ଖଟରେ ଶୋଇଥିଲି ମାଇର କାଲି ତୁମ ମାନଙ୍କ ସହିତ ପାଟିତୁଣ୍ଡ ଝଗଡା ହୋଇଥିଲା କି ନାଇଁ ତ ଆମ ଘରେ ମୋ ମାମା ସହିତ କାହାର ଝଗଡା ହୋଇନାହିଁ ତମେ ଆମ ମାମୁ ଘରକୁ ନିଶ୍ଚିନ୍ତ କହିଲେ ଆସିଲ ପରେ ତୁମ ଘରେ ଲୋକଙ୍କୁ ତୁମେ ରାଗୁଥିଲ କି ନାଇଁ ଆମ ଘରେ ଆମକୁ ସମସ୍ତେ ଭଲ ପାଉଥିଲେ କାଲି ଦିନ ବେଳେ ତୁମେ ମାଙ୍କର କଣ ହେଲା
Merely because
କାଲି
on
ଦିନ ବେଳେ
the day of occurrence, there was no altercation is not the final material. The lordship sees page 29.
ଖାଇସାରି
Statement of Fakir Chand Behra, Fakir Charan Behra.
ଝିଅ ଆଜ୍ଞା ମୋ ପାଖରେ ଥିଲେ ଆଜ୍ଞା 8 ବର୍ଷ ହେଲା ସିଏ ଆଜ୍ଞା ଆଉ ଜଣକୁ ଆଜ୍ଞା ଭଲ ପାଉଥିଲେ 2 ବର୍ଷ ତାଙ୍କ ଘରେ ଥିଲେ ଆସିଲେ ସୁଇସାଇଡ୍ କରିଦେଲେ ଘରେ ଆମେ ଆଜ୍ଞା ସେଠି କେହି ନାହୁଁ ପ୍ରେଜେଣ୍ଟ ଅକରେନ୍ସ କେହି ନାହୁଁ ଆଜ୍ଞା पोस्टमार्टम रिपोर्ट आगे
that is the reason instead of 304 part B now it is 306 it has to be tested
mother in law only
ଯାଇ ସୁଭଦ୍ରାଙ୍କ ଘରକୁ ଆଣିଥିଲି ଗତକାଲି ଜାଣିବାକୁ ପାଇଲି ସୁଭଦ୍ରା କବାଟ ବନ୍ଦ କରି ଲୁଗା ଦେଇ ଆତ୍ମହତ୍ୟା କରିଛି ଖବର ପାଇ ମୁଁ ସେଠାକୁ ଯାଇଥିଲି ଘଟଣାସ୍ଥଳରେ. It has to be tested in
Your lordship.
Already count for the petitioner seeks to withdraw the petition to
only the mother-in-law, sister-in-law.
Court below at the time of framing of charges. With this liberty, the petitioner, the present petition is disposed of all these posts. Have disposed of argued this, yes, all the posts.
Deep.
Yes.
Item 20.
My lord, here your lordship had your lordship had issued notice on 25th of April. My friend is appearing for the opposite party.
Yes.
We have sorted the dispute.
What is the dispute?
My lord, 448, 4.7, 34 regarding the taking over the management of the year, which has been settled by this honorable court in second appeal, confirmed in Supreme Court. Now, my lord, this case is pending since 2007. He is appearing.
Where is the FIR?
My lord, it was a 1cc case originally. It was originally 1cc case converted to city case, page 18, annexure 2. This was the notice which was given on 13/3/24 by JMFC Chendipada. I am on bail. My friend is appearing.
Who is Biro Kishore Patel?
My lord, Biro Kishore Patel was the principal when the dispute was pending before the first appellate court. Thereafter, he was removed from the principalship, and then new principal came.
He's the informant.
He was the informant.
And Hemant Kumar Pradhan?
Hemant Kumar Pradhan was a co-trustee.
Co-trustee. You are appearing for?
For my lord, Hemant Kumar Pradhan.
Who is Biro?
My lord, Biro has received the notice, but he is not appearing because they had settled the dispute. He is nowhere in the picture now. He is no more in the with the college. Nothing in the
Yes, sir. APS to be case of settlement. Just see service of the notice on opposite party number 2.
The noting doesn't show non-service.
Yes.
Your lordship had issued notice to 2 and 3. He has left that premises.
Which address says that?
My lord, that address which was given in the FIR.
Show me the complaint.
Complaint. Your lordship will see.
Show me the complaint. Copy of complaint. You file or not?
No, complaint I have not filed.
Just see, show me the address.
Yes.
940.
My lord,
If your lordship requires, I'll call
Item
for the
31. My lord.
No.
If your lordship requires, I'll call for the CD.
No.
My lord, item 31 is.
Item 31 is the same parties. Parties are same. There is the address given.
Item
31.
31.
31. You've given, where is the complaint? Here.
My lord, annexure 1, page 12.
Complaint indeed.
Gobindo, he has died in the meantime.
Yeah.
Biro Patel was the witness there. The two complaints.
No, you show me that Patel's address.
Yes, your lordship will see name of witness engineer Biro Kishore Patel, son of Gopinath Patel, at post Chendipada, district Hon'Ble, working.
Show me the file now. Show me the file service. In both the cases, service. The earlier file.
There he has.
What was the address given?
My lord, I have given the address which was given in the FIR. This is his residential address which I have sent notice. This is the residential address which I have given in the notice. Annexure.
But he has alternate address here. Just see page 31.
No, he was working that it was Chendipada. When he was working as principal, he was at Chendipada. Now he has shifted to Deogarh.
Why I am asking is, if you have sent the notice, address he has left, there is a judgment of Supreme Court which says that in the correct address if you have sent, it is treated to be right address. Show me the address, correct address you have sent it or not.
Yes,
that's what I am asking.
I have sent it in the correct address where he is now residing. He is now residing. Or if your lordship wants, in both the cases, let me take by paper publication, because that will suffice the.
Why paper of publication? If you have sent in the right address, then that Alvi judgment will cover you.
My lord,
show me address. That's what I am struggling to get it.
My lord, that.
Show me address for the this opposite party number 2, so that I'll take it as a sufficient address.
My lord, that address, complaint petition I have not annexed in item number 20.
You
I have not
filed that complaint. To file additional document to substantiate any additional document to show the address of the opposite party number 2. Opposite party number 2. Notice was issued in this matter to the opposite party number 2 and 3. In the given address, the
residential address.
Given address of the opposite party number 2, notice was served, a notice was sent. However, the same is returned with a postal remark that the addressee has left. Addressee has left. Therefore, Mr. Bose, the learned counsel for the petitioner, seeks to file the copy of complaint petition so as to ascertain the address of opposite party number 2. Or so and so enters appearance for opposite party number 3. These the matter of the interim order.
No, there is no, your lordship said that after their appearance, your lordship will pass that in.
Now, since he is appearing in proceeding before which court?
My lord, city case number 2082 of 2007, Chendipada, GMFC Chendipada.
Okay. In view of the fact that the opposite party number 3 has already entered appearance, and he submits that the matter has already been settled, and insofar as the opposite party number 2 is concerned, the notice has returned, answered with a postal endorsement that the addressee has left. I'm inclined to grant interim direction. Accordingly, so for this state.
My lord, item 31 is also
31 same.
31 same, but city case number is
City case
different.
number is 31 same.
Well, both the matters may be tagged together.
Tag together, both the matters. 31 tag kariyo, same order. Yes.
My lord, I'll produce that so that it will suffice both the cases.
So that I can take
Yes.
note of the service.
Yes.
And on the ground of settlement, we can go ahead.
My brother is also appearing in that 31.
Right.
Also.
Yes. Next.
Both the matters interim order.
Yes, interim order. Yes.
21.
May I please?
Yes.
My lord, last occasion, this honorable court passed out for adjournment in the court below, along with the notice to opposite part number 3. So that I never heard that notice. So I filed this requisite on 14th. So the 3-day holiday was there. Kindly be adjourned today and fix some other date.
Adjourn simply, adjourn simply.
Lord, if a lordship permits, my lords, I don't stand on the way, my lords. Last occasion, I assured this on courts and also to my learned friend that the judgment, my lords, it says about what is the fate of that waiter, my lords, in case the main accused dies, my lords. What is the stage and at what he can get the benefits? I'm giving the citation, let him examine, my lords. And 2000
some other date, my lord.
So I don't stand at the way. It will be urgent. So verify this judgment, 2014, write down.
Write down.
2014. 2014, volume 11, Supreme Court cases, 724.
2019. 724.
724.
724.
The another two, this is, just verify this one. Another two, this is
In the
staring
same
at.
line, other judgment also, you take it out and see. Okay, adjourn.
22.
May kindly fix after vacation.
Yes.
22.
May I please, your lords?
Yes.
Now, the petitioner seeking this application for waiving out the condition imposed by the learned lower court is at page 18, your lordship.
18, huh?
Yes, your lordship.
Okay. What are the conditions?
The condition, last bottom, my lord, he shall appear before the trial court personally on his date of posting till conclusion of trial without any excuse. The bail bond shall be forfeited on a single default on the part of accused to remain absent in the court, and the accused will be taken into custody. It is made clear that no petition under section 317 of CRPC will be entertained on the date of posting of hearing of the case. Surprisingly, the surety interested to take the accused on bail must furnish their mobile number, email ID, and shall remain present in the court on the date of a hearing to take further direction from the court, my lord. The petitioner is a student. The petitioner is a student. And the case is triable by magistrate. Out of 12 witnesses, 7 witnesses have already been examined.
You have been treated well. What are the offenses?
Offenses are triable by magistrate, 385, 506 and
Right, petitioner is agreed by the order dated, petition is agreed by the condition imposed by the court below while enlarging him on bail by order dated 3/2/2024. The condition by which he is agreed reads as under. Condition order page order it is last. Page order last. He shall appear. One condition number.
Only one, but given all the conditions in that one condition.
Not for the petitioner submits that by the offences are triable by mistake, and by imposing the condition, the statutory right for the petitioner under section to move to avail the benefit of either section 205 CRPC or 370 CRPC is taken away. It appears the condition imposed by the court below are unreasonable while granting the bail to the petitioner. Rather, it is onerous one. Therefore, I modified the condition and modified the condition. The petitioner is directed to appear before the court below during the trial. During the trial.
As and when
the rest of the conditions are waived.
Deeply obliged.
Yes.
The condition. That's okay. Oh, sir.
No, sir.
Yes, outside. Like 1 minute. 34. Sir.
I thought Lordship had gone for early lunch.
No.
Sorry.
We saw you there for you.
Well, no, obliged. My lord, there is a case here.
Yes.
The rejection of.
My lord, before my senior submits, I have not received the copy of the ID.
We have given yesterday.
No, not sir.
It has been served
to the file also.
Huh?
Yes, I have checked the file also.
For ED. For receive but yesterday.
Whom you have given?
For ED.
This is not, I am appearing in the court, my name appears.
Oh, you see the they do what a copy.
Signature bag John for ED. I have appeared when my senior last appeared before my Lord Justice S. Rathore. And my name appears in the list. I have not received the copy.
Unless we serve it, we can file it also.
It's all right. There may be
normally the practice so far our High Court is concerned. The concerned department, counsel, if any there, or any office is there, we are serving. And as a matter of fact, that has been served. So ED is having number of concerns. So I don't know whether in fact.
Lord, I have checked up in the morning from my IO. My IO has also no intimation that such an application.
You give a copy because his name is appearing in there.
Sir, we served it. Lord, limited question. The rejection of 205. Here the case in not say, my lord. A police case was registered in the year 2008 against.
Do you need the copy? Then you can.
I have just received, Lord. I have to take instruction also.
Like my senior Monday?
Yes.
Monday.
I thought my lantern must have collected Because it is normal, because my office is having an acknowledgement. That's
all
it.
right, let
At 10:30, my lord, I have taken instruction. My IO has also no intimation that such a copy has been received.
It's all right. Now, Monday.
My lord, he appeared, assuming he appeared in July 2023. He would have probably in between he must have met me 10 times. No. Supposing it is not fair, at least to
You, the problem is when he made.
at least the boys, at least the boys. In 2008, the police was securely the Bhatta like it. The Gita College staffs were carrying cash of 12 lakhs to purchase from agriculture public. That is 2000. So the police were carrying this money to pay to the North College. On that, the cash was seized. And that case is 2008. Suddenly in 2019, PMA means ED authority summoned us in section 3.
No, I think the same, there was another case.
Another thing?
Procedural Mishra was the case. Same. And the whole, that is in the Raigada.
Yes. That is in the Raigada. And the two things are very clear. Section 19 they did not indicate. In immediate arrest and all that. That they did not indicate. They summoned us in section 15. We produced all the documents and the bank statements, everything. So then they did not do. And the persons who are all above 65. And 205 why I write the summon issues either appearing persons or unpleaded. So normally 205 application we have filed.
You just please take it up. The same 80%, the same story.
Not the same 80%.
Same 80%. With Konda and two Konda and they are the board of directors. Yes, board of directors. So they are the directors and he is the registrar or something. Number one is the registrar.
Now the
registrar and the.
Let me check out. Where did I apply?
05 only. Yes. And he said that after to allow me 205 and after committal the matter will be transferred to Hon'Ble, then I will be. I recorded that and allowed. Exactly.
No man. You put the issue that is so far the police case is cut. That is the police body. The police case selected a case in 2008. Pending that criminal proceeding, the reason was filed in 2000.
This is ED case that police.
Yes. This is ED case. So when ED case is concerned, because you are invoking a proceeding under section 15 only after 11 years. That is in 2018. And 2018 you summoned us in section 50. We produce all the documents.
That is on merit.
That is on.
That is
and now the question is limited. 45 provision clearly permits that you can accept if normally in dispensing appearance, if the money amount is more than one, less than one. Here the money amount is 12 lakhs. That is one proof. Second is a lady or a infirm. So these people are informed. 65 above all the 3 persons.
So that's
the only part. But even the only thing is, supposing the court directs to appear, go on bail, and appear in latter date in 370.
Yes,
that's no problem.
Just see and get that petition. Because if both the cases are emanating from the same incident, and you are taking some stand there, some stand here, that is not correct.
No problem.
You have taken different stand. You just check it up.
I'll check it.
Yes.
Yesterday, Lord, I was searching the website. I could
because in the meanwhile, what has happened?
Found 8 cases. So I have to also check up those cases also.
In the meanwhile, what has happened? 5 days back, the date was fixed. The learned counsel filed a petition saying that our revision application is filed, the ED has appeared, so let it be adjourned. The learned district judge said, no, so many dates, 9 months has over, nothing has come, therefore BW has been issued. So that's the reason.
BW only, no.
So can it be on Monday then?
Monday, yeah. Next.
And one more thing, 137th period, and learned friend is appearing. I think it will be too long, at least 2 5. Can it be after vacation?
Interim or to continue?
Interim to continue.
Same dispute.
My lord's conciliation, in fact, failed sorrily after consent.
They will
withdrawing from consent.
They will subsequently realize.
Okay.
Yes. 23. 20? Yes, 20.
May I please? Not here.
Yes, sir.
I had to take instruction, my lord, whether there is a possibility of compromise or not in this case.
My lord, in fact, the offense?
Offense 468, 471, 409, 420, which are not attracted, arises out of purely a civil litigation. Police submitted final report.
He says that settle the dispute.
Your Lordship, I can show through documents.
No, I'll what I'll do is I'll send it for mediation.
For mediation.
We try. It doesn't happen, then we'll see.
My lord, for 2,000 rupees, I am having the draft. It was long back, 1 year before he was directed to take instruction. If he will take this draft and matter will be closed.
I can't, my lord. My lord has planned.
He has
Not by instruction.
Twice I have got draft and those have been invalidated.
Dispute is only 2/3.
Less than 2,000, but I
No. It is not less. It is in that way. But as my lord, the gift deed was my lord executed by the.
Let me present. My lord, 6 daughters. One, the father executed a sale deed in favor of 1 daughter and her son. That was set aside by the civil court at the instance of another daughter. But still then the records continued in the name of these accused persons, mother and son. So the filing aid amounting to 11,000 some odd was disbursed to these petitioners, these mother and son, because the records were standing in their name.
They are party in this.
I'm just
But the opposite party is related to
sisters. ମା ପୁଅ ଆରପଟେ ହେଲେ
ଗୟାସୁର ପ୍ରଧାନ।
ହଁ ସେ ଆଉ ଗୋଟେ ଭଉଣୀର ପୁଅ ଏବଂ ପୋଲିସ ଯୋଉ ଫାଇନାଲ ଫର୍ମ ଦେଲେ ସେଥିରେ ଲେଖିଲେ ଯେ ସବୁ ଭଉଣୀ ମାନଙ୍କୁ ଯୋଉ ଅନ୍ୟ 4 ଭଉଣୀ ରହିଲେ
how are you saying 2,000 dispute property dispute
12,000 no filing aid was received 12,000 11,800 some odd. I paid it to all sisters. These sister sons didn't accept and filed 1cc case.
What was the value of that property?
No, property is not a good dispute now. That filing aid. Crop loss ହେଲା ବୋଲି filing ରେ ଯୋଉ aid ଆସିଲା 11,000 କେତେ ଟଙ୍କା ସେଟା ଆମ ଆକାଉଣ୍ଟ କୁ ଆସିଗଲା ଆମେ ସମସ୍ତଙ୍କୁ ଦେଇଦେଲୁ କେବଳ ଗୋଟିଏ ଭଉଣୀର ପୁଅ ନେଲେନି କେସ୍ କଲେ ପୋଲିସ ଫାଇନାଲି ରିପୋର୍ଟ କରିଦେଲା as mistake of fact. ତାପରେ
small dispute, why are you not?
Again, very trivial matter and 2,000 rupees draft. I am ready whenever.
You Lordship may visualize one thing. A suit was there. They were parties
But
in
see,
the.
you can't arm twist the accused person for this dispute by filing 1cc case.
No. That is protest petition was filed.
That's right, but
The magistrate may not, after considering all the evidences on record, took cognizance.
Technically you may be correct, but what is the offense?
Offense is my lord 468. My lord, what has happened? Your Lordship may kindly.
How 468 is attracted?
Your Lordship may have objection. They kindly see the allegation. Allegation, my lord, what has happened? The sale deed and gift deed was executed in their favor.
Then I'll see. I'll examine it. And there is a chance of causing. I'll just send it to mediation or try and settle it up. Right off. The dispute is the petitioner and the opposite party are related to each other. The dispute is appears to be a family dispute pertaining to the property. So therefore, there is a possibility of out of court settlement. In view thereof, the parties are relegated to the mediation cell. Where is that High Court mediation cell or somewhere else?
Yes, High Court.
Bottom, High
Bottom,
Court,
High Court mediation.
mediation cell. The coordinator is directed to
Oh, yeah.
fix a date and intimates the same to the party for the purpose of exploring the possibility of a settlement, possibility of settlement, awaiting the mediation report, leave the matter service of state, date is given, the entry order to continue. Yes. Trial.
25.
Yes.
May I please, your lordship?
Yes, sir.
This is a case where a check was presented to SBI Janpat Road, Bhubaneswar, and check bounced from there. But the cognizance of the offence was taken by SDGM, learned SDGM Khurda, which is barred by jurisdiction. So thereafter also, he also proceeded with the trial.
Have you moved the application before the court, that court, saying that you don't have jurisdiction?
Lordship,
you will go to that court and tell why 482.
Lordship, we came because we didn't file any application, but
you have to go to that court only. You have to tell that you don't have jurisdiction unless you go and tell that. Why?
We have raised such things, but
where you were raised? Challenging the cognizance.
My lord,
thereafter also.
just I am submitting, my lord. My learned friend statement is wrong. Why I am saying so? That ultimately that petition has been rejected. After 1.5 years, they came before your lordship to quash the proceeding. They have suppressed the material fact before this honorable court. On that score alone, that petition may kindly be dismissed. I have filed a written notes of argument, my lord, and the entire now at the hearing stage, they are in appeared before the learned SDGM, learned court below, and they cross-examined the complainant. And the complainant side, all the witnesses have already been closed. The evidence at this stage, my lord, they are saying, your lordship kindly go.
Lordship may kindly
written
go
notes
through
of argument.
461
Suppress the material fact.
You tell me whether you have gone to that court instead of moving application before that court saying that you don't have jurisdiction. You participated there.
Yes.
And they allow the complaint to go on.
Yes. Cross-examine also.
And everything you have done, now you are coming and filing 482. What is this? For the petitioner, in this petitioner is checking, quashing up for the 1cc case number 111 of 2021, pending for the court of JMFC Khurda, on the ground that that court has no jurisdiction to try the case. Shown to a piece for opposite party submits that the complaint case is at the trial of the complaint case is at advanced. It is apparent from record that the petitioner had not raised this point before the court below, rather refused to participate in the trial. Now, be that as it may, I am not inclined to interfere in this matter. However, liberty is granted to the petitioner to move appropriate application before the court below, raising the issue of territorial jurisdiction. If such application is moved, same substantial on its own merits. Disposal. Yes, next.
I have also
next.
Even the further affidavit also. That
won't tell.
File.
Here.
26.
May I please, Lord?
Yes.
This matter relating that final disposal matter. One matter yesterday, I find that there are three matters. Three matters. Yesterday, those three matters were listed, but one matter is not there till in the list today. However, this is a case, my lord, where the learned magistrate is proceeding with the case without there being an order of cognizance. This is a very interesting case, madam.
There is no cognizance.
There is no order of cognizance.
Yes, Mr. Maharaj.
My lord.
No.
Cognizance is not taken.
Maharaj may not be party
It's a 138.
138. Yes.
Kindly see my prayer portion, my lord. 30, it's here length is 30.
No, I am saying 3881.
How many
First case,
cases?
my lord, first
There are
case.
3 cases were filed. I filed 3 482 applications in respect of 2 complaint cases. 2 complaint cases relating to that. It is stated that the
Are you ready?
My lord.
Are you ready?
My lord. 3073 case.
No,
my
in both the cases, are you ready or
My lord, my
not
lord.
ready?
My lord. Ready, my lord.
Ready?
My lord.
Okay.
3881, in fact, a notice was not been issued. However, since my learned friend has already appeared, here this is your lordship will find from first going to the before going to the order of cognizance.
You say cognizance is not taken.
No, sorry. The order on the basis of which the proceeding was continuing. But this case, your lordship will see page 25.
Well, which one? The second one?
3881.
20?
25.
25.
Annexure 1.
25 is not annexure 1. Annexure 4.
Uh, 3881.
Yes.
CRLM.
Yes.
Okay. Yes. One. Yes. That I was seeing that. Yes.
307.
One. Yes. First order.
On
1921.
Yes. The complaint was filed. I am just showing that this complaint was filed on 19/7/2021. Thereafter, on 22/7/2021, a petition for condonation of delay was filed by the complainant under section 152B. On the next page. Thereafter, the case was continuing because of the non-appearance of the party due to arising out of COVID. Then relevant person is page 28. Order dated 25/7/2022.
Yes.
The learned advocate for the complainant is present. The case record is put up today for a hearing on the point of limitation. On perusal of record, it is found that this is a case under section 138 NI Act. The cause of action for filing of the complaint petition arose on such and such, for which the complaint petition should be filed within 1 month, that is by 36/2021.
Come down. That in view of the direction of the Honorable Supreme Court cannot be held that the petition is beyond time.
Thus,
the purpose of so and so.
I'm coming
the
from
complaint
thus.
is directed to file a complete requisite for issuance of a process and so on. So. Yes.
Yes, here the prox lies here. How can process will be issued? Here, there was a delay. The delay was not condoned after giving notice to the accused. It is the mandatory mandate, as your lordship know that very well, so many decisions are there to that effect.
Where have you moved the application to court below?
No, I am the accused.
I know you should have moved an application. You can't proceed. After summoning,
no.
You moved 305. 205.
205.
You didn't move that.
No, that application was not moved.
You should have moved the application.
But another thing that, where is the order of cognizance?
That you should have said that summoning order was bad.
But that, seen in view of the Adalat Prasad decision, the magistrate has got
no
jurisdiction to recall. Magistrate cannot recall the order of cognizance. Magistrate has no power. Magistrate has
What do you say?
My lord. 3073 cases, my lord, they are obtained interim order, my lord. So he has a challenging before this honorable court, my lord, for the call for the record of GR case number, my lord. 3073 first case, my lord.
No, you answer what he says.
In the limitation of ground, my lord, he has not
cognizance, he should summoning order.
My lord, he has not.
My lord, in addition,
petition before the trial court. He has not.
I am asking something, you are answering something.
Without taking cognizance, how?
Without taking cognizance, summoning orders were issued. So he is questioning that. How do you respond to that? That's what I asked, whether you are prepared or not. Not prepared, sir.
Not prepared, is
Yes, the way he is responding. Then counsel for the opposite party seeks an adjournment as he is not prepared in both the cases. Matter is adjourned to such interim order.
Along with that 4182, which has been missed.
Both the cases.
No, no,
both the cases.
3 cases were there. I would have list heଇ ପାରିନି କିନ୍ତୁ ଫାଇଲଟା ଆସିଛି
ଦେଇଦିଅନ୍ତୁ।
ଗତ ଡେଟରେ ଥିଲା।
Show କରିବେ। Next time you prepare and come. That is why I asked you. We should not have wasted 10 minutes. Yes.
27, may I please, my lords?
Yes.
My lord, this is an application for pausing of the entire criminal proceedings. My lord, in this case, what has happened that, my lord, before going into the merits of the case, my lord, I am the manager of Watco, my lord. There was an EPC agreement between Watco and my lord, an contractor, which is at annexure 4 series, my lord. So, as per that agreement, the entire work has to be done, my lord. And this matter pertains to, my lord, the death of 4 sanitary workers of that work tenure. So, my lord, now I'll place my matter on.
This will take many times, much more times.
No, my lord, this
Stay
will
has
take.
already been granted.
My lord, this will hardly take 5 to 10 minutes, my lord. This is a small matter, my lord, although the EPC agreement makes it voluminous.
Release the matter.
But this is small matter.
Yes.
My lord, just the EPC agreement, my lord.
1 minute. It will take time because many matters are there.
My lord, this has been added
Entry
several
order.
times.
You have entry order. Enjoy.
अरे हमने मैंने अच्छा दिन है केस टा रही but बहुत समय लगे
5 minutes.
Entry order. Continue. Entry order continue.
तो stay ଅଛି ना
हाँ stay ଅଛି. Yes. Next.
28. May I please the lordship, my lord?
Person finance.
Yes. Here, my lord, though the petitioner, my lord, filed this application for quashment of the proceeding, but in the meantime, my lord, one senior, my lord, appeared and the matter has settled.
Yes.
And to that effect,
Settled, my lord. Yesterday, I filed an affidavit of the OP number 2. And the matter has been settled between the parties. And he wants to withdraw the complaint case filed before the session judge Bhuvneshwar.
You are the complainant.
I am the complainant.
Okay. The petitioner had challenged the order dated 22/8/2023 passed by the Latin Sessions Judge Kurda in ICC bracket protest petition case number 4 of 2023, whereby cognizance for offence under section
offence under section 294, 506, 34 of IPC and 31, that is on 60.
294, 323, 506, 34 IPC and reading section 3(1)(R) S of ST and SN.
Has been taken. Yes. Notice was issued to the opposite party number 2. So-and-so enters appearance and submits that the matter has already been settled. And he has got the instruction that his client would withdraw the petition pending before the court below. Accordingly, an affidavit has been filed, which is taken on record. In view thereof, the present petition is disposed of with the liberty to the petitioner to take appropriate step as per the settlement.
With liberty to the opposite party because
the opposite party.
He becomes.
Next.
29.
My lord.
Yes, sir.
The coordinate bench has directed the call for the status report that has come, my lord. The background of the case is that, my lord.
Criminal division.
My lord. My lord, in the year 99, FIR was lost.
Challenging what?
My lord, discharge petition was not allowed. Denial of discharge petition. My lord, you may see, FIR was lost in the year 29/9/99.
Vigilance case?
Yes, my lord.
You are referring.
And
1 minute.
My lord, this is an application, my lords, My learned friend is fair enough to say that this is an application they filed for alteration of the charges under section 216 of CRPC. That was turned down, my lords. Now they prepared the revision, my lords. Now 216 application for alteration charges, my lord. My submission would be that is an interlocutory orders, my lord. Under section 297 to 397 2, my lord. The power of revision conferred at subsection 1 shall not be exercised in relation to any
The revision is not maintainable.
because the order passed, which is an input, my lords, I'll show to your lordship, my lord, not finally deciding anything matters. One, the test number 2 is that if the revision is allowed, the lease is not even disposed. My lord, let learned friend examine all these matters, my lord. Lordship may now turn to page 2 of the petition, my lords, to verify the ascertainty. Page 2, paragraph 2, my lords. Dear lordship, get that one? Page 2 of the revision petition, para 2, my lord. In view of the submission made,
Yes.
it is
Yes,
expected.
one thing.
216 CRPC.
Will you examine it?
Yes, my lord. Lordship, may
And move an application.
Well,
Move an application rather instead of wasting time. Move an application. Converting it to
what happened, your lordship may see.
And
99, my lord.
Let me glance through, my lord. If that the trials
Your lordship,
begins
my
in the
background,
meantime-
lordship may had it for a moment. 1919 an affair was lost.
No,
For
I don't want
loss
to
of-
go into merit. First,
Yes, my lord.
come out of this problem.
Yes,
Come out of, what is the status now?
The status report may glance through, my lords.
That is
By-
there on
by-
record.
One minute, by the order dated
Like-
24/11,
My lord, when
2023,
prosecution,
my lord, the
I
earlier,
left at my lord. What remains, my lord?
if the trials begins, my
And-
lords,
Own High Court judgment we have referred, but Lord Court be the had still in
it's a
negative.
scrutiny, that these are all defense please can be raised at the trial, lords. If the trial begins in the meantime.
25 years has been passed.
Also, you, what is your name? Your name?
Ashutosh Behera. Hello.
I'm sure charge has been paid. I did not, my lord, he could not have filed an application for a modification or alteration of charge. After the charge is paid, my
I
lords,
mean,
the
least
trial
penalty,
begins.
Lord, charge
Then
has
the
been-
trial begins automatically.
If somebody died and you challenge the charge order.
My lord,
you might have
what
taken-
is the
you
my
might
lord,
have taken
allegation
stay-
against me is 17,000. My lord,
Those issues.
more against 17,000 allegation, and that has not been disbursed by the authority, my lord. That is their own record. As you nije kouchen FIR file kouchen, you can't establish the case.
How many writ petition, how many?
My lord, in the writ petition, twice
And
6 months time has been granted to
and in the-
conclude the my lord proceeding.
How can it be? See, somebody is filing a revision getting stay, somebody is died.
No stay is here, my lord. Here we have not never prayed for.
That is what the report is, status report.
My lord, what happened? Your lordship, I am just
Court has
background.
given, have you seen the report?
My lord,
Have you seen the status report?
I have not seen, but they filed FRT.
Not if the
FRT has
revision-
been filed by them. And that was not
And
accepted by the court.
The order
That is the
is revisable.
and your lordship
Chalo,
may see.
you just get over this problem, then we'll
Yes,
get.
yeah, they
We will not waste further time.
But input order at space 11, input order space 11,
You
it
move an
says that
application,
the case record is student, a petition filed on behalf of the
An
accused
application for
petitioner.
converting it to criminal misdemeanor. Revision is not pending.
Oblige.
Yes. Next, simply addition code 30.
30, item 30.
30 here.
Well, last time your lordship had issued notice and this matter could have been settled because in view of an affidavit filed. Well, my instruction is if your lordship gives the matter after vacation, the lady can come up.
Yes. Adjourn at the request of Mr. Marana, entry mode to continue. Yes. Yes.
32.
So item, I'm sorry, I'm extremely sorry about it. Item 29, my lord, lordship adjourn.
Okay. 32.
As per my lord,
Yes,
I
sir.
read some yesterday, all are present before.
Yes, all are present. Now call them. Bharat Bhushan, Pramod Kumar.
One prosecution had filed an application to accept certain CD records, my lord, audio CD records, my lord, into record to bring into evidence.
Who are you?
I am the accused. I am the accused. My lord, I had this is a case, my lord, where he said they had promised to marry, but did not subsequently refuse to do so, my lord. There is a case, that was my lord.
370.
Sometimes, my lord, sometimes he says also he had married also. Said so. My lord, whatever it may be, when the prosecution was started, my lord, he had been examined. Three witnesses have been examined. Thereafter, this informant by the victim, my lord, the PW4, my lord. Your lordship, if your lordship will kindly go to page 21, started the evidence, my lord, that is on 25 February 2021. That was referred to some other day, my lord. Thereafter, on the day it was referred, he filed an application that your lordship will see, that is page 17, annexure 3, saying that he has already produced already some
you said in the 3 mobile phone you have recorded the nude photograph of the lady and compromised position photographs and all. You converted that to a CD.
Well, not converted. He said that audio CD. He said audio CD.
Whatever.
My lord, but
He wants to produce that.
My lordship, there is no record.
Produce the CD during the trial, as the same could not be produced during the investigation.
Your lordship, kindly go to page 17. Page 17. Your lordship, can say last paragraph 3.
7?
Page 17.
Okay.
3 देखो. 3 से कहला, the informant prosecution witness has produced such CDs before the court during her examination. Court says that no such CD is there. That if your lordship will see page 30, middle paragraph. On perusal of the case record, it is found that the victim has yet not produced those CDs in court. As the prayer of the learned additional PP is allowed, the victim is directed to produce the CDs. Instead of filing petition, say he has produced CDs, but really it was not produced. So no, nothing was brought to my notice. Well, I'm not on that, my lord. I am on, my lord. On the as far as the 161, 164 statement is concerned, there is no matter about the such CDs, my lord. Any of the CDs, nothing there. First time it was stated before the court that I have CDs. No, it is not given to the also police. He admits. My lord.
Which way he is agreed by, I don't fail to understand. Which way he is agreed by? If CD there, he is saying that there is no such CD. If there is produced CD,
Improve a story. My lord.
That you confront with her.
I have I have filed my objection, my lord. Objection is specifically stated, my lord, that since the allegation are made in the present petition is contrary to the matters of record reflected in the charge sheet during the investigation, the production of any extraneous document is not permissible. So what I wanted to say, that is completely extraneous, that is not connected to any prosecution case, my lord. First time it is stated, my lord. And if your lordship by the date of filing that application, my lord, the 161, 164 and her evidence, my lord, her evidence is page 21 and limited.
The idea of the trial is to find out the truth. The court wanted to get that CD.
My lord, what it is required, my lord? If a schedule is produced, then question the audio series is saying further required.
You tell me if you can satisfy me that legally it was not permissible. Show me provision.
Well, legal.
Factually, you don't have a case. Legally, if there is a bar, you show me. Because of the legal bar, I will.
Learned court below, while hearing the matter, it is postponed, my lord. Postponed said that you complete the evidence first to the victim, my lord. Said complete the evidence first. Thereafter, that petition will be taken out. According to that was done, my lord. And if your lordship will see the entire evidence.
Now what is the stage?
Well, stage is after that witness, further witness to be examined, my lord.
Victim has already been examined.
Cross-examined.
And Cross-examine.
Cross-examine.
You, better that you should move an application at 311 recalling in view of this.
I have recalled one petition, my lord. Your lordship, that order, your lordship, I have recalled petition to contradict certain points, my lord. That was also allowed.
Allowed, my lord. Naturally, I have not seen because some new material has come. Opportunity to confront will be there. Given, my lord. You got that opportunity.
Your lordship, your lordship.
And you also you can confront.
I CD question.
You can confront, sir. That is the trial.
Sir, my first question is that was what is not produced before the IO. Whether is at the court, first time she say from the pocket that this is my CD.
That is how you have to confront with the IO. You have to ask him.
My lord,
I need not tell you how to.
Permissibility of whether it can be permitted. That I point out. Suppose.
Show me legal bar. Show me the provision legal bar. I'll just quash it.
Your lordship, your lordship.
Actually, you don't have a.
I'll bring it, my lord.
Not what bring
it. One case is there. My point is very
after
simple,
wasting 15
my lord, my point is very simple, my lord.
29 for
the matter which is not at all in record, not in the police investigation report, whether one person can come to court, file deposing evidence.
Not one person, victim.
Yes, maybe victim. Victim says that this is this document I want to produce. Whether that can be permitted. And this is particularly in respect to the electronic record, my lord.
For that reason, my lord, he had taken time on 29/4, my lord.
What?
29 ଥିଲା ନା ଏଟା
29 ମୋର ଡିଫେକ୍ଟ ଥିଲା ମୁଁ ଆସିପାର ନଥିଲି ଡିଫେକ୍ଟ ଥିଲା ଡିଫେକ୍ଟ ଗୋଟେ କପିଟେ ସଲ୍ଭ କରିଥିଲି ବୋଲି କହିଲେ ଯଦି ଦେଇଥିଲି ଆଗରୁ ଆଉ ଗୋଟେ କପିଟେ ଦେଲି ଇଏ କଲି ଏଟା
Okay, I'll pass your.
এই পয়েন্টটা যেটা কোন পয়েন্ট whether he has it can be accepted by the court. Mr. Senator, I will bring the decision of this honorable Supreme Court, my lord. ଆଜି ଆଣିନି
ମୁଁ କିଛି ବୁଝିପାରୁନି ଆପଣ ଏତେ ପ୍ରେସର ରେ ଆପଣ ଇନଷ୍ଟଲମେଣ୍ଟ କ୍ଲିୟର କୁ କରିବେ you should have come with this point. This is the only thing we have to answer.
I have a very simple point, my lord, that the material or what we are going to lead the evidence, that is not a.
You need not repeat. I understood this much. You show me any legal bar from the statute book or some judgment. Then I'll interfere. Otherwise,
statute book 231 year lord.
Okay. I am reserving it. You give judgment.
231
just
I'm
reserving the judgment.
Judgment no 231 होची हमरो CRB से
लिखि दियो जाहा दियो
आपण जहां भी जजमेंट जहां भी देबे आपण इन राइटिंग गुटे दे दियंतु आई विल कीप इट रिजर्व डोंट वरी गिव इट कीप इट रिजर्व यस
35
रिटर्न आर्गुमेंट छोड़ोटा दीजिए
रिटर्न आर्गुमेंट
ठीक है यस
35
May I please the petitioner filed this challenging the initiation of the FIR against the present petitioner in an option 419, 420, 467, 468, 470.
छाड़न तू सेक्शन पढ़ी भी ना कौन पूरा
Your lordship मैं कहूँ
FIR में लॉज ही थी
FIR कसके
अब गोटे पेज रे FIR लगाई फाइल कर दीजिए तो
मतलब fact is like this.
No, fact, forget about fact. I don't know. Just few days back, FIR is lodged.
Charge sheet in the meantime, sir.
Where is the charge sheet? Nothing except 3 pages FIR. You have not filed anything. You want passing?
May I pray tomorrow or day after?
Tomorrow. Let counsel for the petitioner seeks adjournment to file additional document to substantiate the case urgently.
Charge sheet number
36.
Yes. पूरा पिटिशन तो फॉलो करी फाइल करिवे कोन लेखुचोदी कोन नहीं किसी ने गोटे पेज रे पिटिशन ते फाइल करी बस पास कर दियो यस
36
Nobody
36
passing of proceeding
none appears for the petitioner in the interest of justice.
37
What is this matter? Anything survive?
Question of proceeding.
The problem is nobody comes and unnecessary.
37, my lord.
1 minute, 1 minute, sir. 1 minute, sir. To file the table.
No. Francis case. Are that the JR case, my lord?
Is there anything survives?
Criminal proceeding as well as FIR.
This is the matter. Nobody appears, I think, earlier. Huh? Why are you making me read? Withdraw. Yes. Next 37, huh?
37 time ନେବି ଫାଇଲଟା ମିସପ୍ଲେସ୍ ହେଇଯାଇଛି
ठीक है, ठीक, no problem.
ହଁ
Urgent.
ମୁଁ ଏଇଟା
On
ଗୋଟେ
request, urgent.
ଆଜ୍ଞା ଗୋଟେ କପିଟେ ସରକାରଙ୍କଠୁ ଜେରକ୍ସ କରି ନେବି
ଆପଣ he is your dear friend, you can get it. Yes.
38.
ପାଉନାହିଁ ଫାଇଲ
Yes.
Petition the matter is compromise between the parties. They are not appearing for settle between the parties. They are not appearing. After vacation, they may appear.
They will never appear, my lord. What happened in this case, my lord? The informant came forward here, my lord, saying that the matter will be
Because it is a final
the
report.
persons, my lord, they are heading outside. They are not, never, you are also earlier directed the parties to appear
come.
before the IO, my lord. IO, my lord, when I contact IO, he stated that they will never come to me. But since investigation,
You are the informant.
I am the informant.
Why are you so keen?
FIT was filed. Final report, the case was closed. Court has taken some more cognizance.
Then why are you worried?
Because now the matter is compromise between the parties.
And if the accused persons are not interested, why are you worried?
You will also give a last chance. They are appearing.
I don't know. Despite notice,
The notice has not been sufficient. The lawyer is appearing for on the
who forget the accused persons are so
not appear before the IO.
And you are the informant.
Seat पर है कि नहीं तो appeal किन करी भी.
What is the prejudice to you?
Because my lord, the dispute between the company and the petitioner is a finance company. This petitioner has taken a loan from the company to purchase a vehicle.
Okay, but you are the informant.
Yes, my lord.
This petition is filed by the
Yes, my grant liberty the trial court to that may better.
informant seeking quashing for the criminal prosecution against the opposite initiated by him against the opposite parties. Opposite parties. None appears for opposite party despite effort being made. At this stage, Land Counsel for the petitioner seeks to withdraw this petition to
Direct the trial court to conclude trial.
move appropriate application before the court below in this regard.
Conclude the trial.
In this regard, with this liberty, the petition is disposed.
They mentioned that the conclusion of trial that may be expected the such purpose. The case is lingering since long.
I don't know whether you are appearing for the accused or
I am for the informed.
It means what a date. It means what a date.
What a date. Be happy. Yes.
Lawyer is appearing for open.
Non-appears for. Despite non-appears. Non-appears. Yes, non-appears for. Yes.
39.
On behalf of Mr. Naik, I prefer after vacation.
What is this matter? कौन अच्छी ना नहीं किस मैटर रे
गाड़ी से फोन करी कहले
in the interest of justice adjourned to service it made clear that no further adjournments are given. Yes.
40.
Yes. None appears for the petitioner last time. Last time,
none upset.
When the matter was taken up on 7/5/2024, none appeared. None appeared for the what number it is? 40. 40. None appeared for the petitioner. Even today, none appears on behalf of the petitioner. It seems the petitioner is not interested in prosecuting the present matter, and the same is dismissed. Yes.
41.
Non-prosecution. 41. Yes.
May it please be your lordship.
Yes.
Lordship, this is an application seeking quashment of FIR in Dhenkanal Town PS case number 244 of 2022, or dated 26/4/22,
Yes.
which is under Annex
What
1.
are the offences?
Offense under section 498A,
Yes.
294 500.
Notice final report has been
No, your lordship. I mean, I have not annexed the final report here.
What is this annexure 3?
Annexure 3 is the final report of a prior FIR, which is on the same fact. That is what our ground of assailing this quashing of FIR. Your lordship may kindly see the annexure 2.
Which FIR you are seeking quashing?
Quashing of annexure 1. Annexure 1.
And in the final report is vis-a-vis annexure 2.
Annexure 2, your lordship.
Okay.
Yes.
Issue notice to opposite party number 2. Written about. Okay. Huh? There are 3 cases.
Yes, your lordship. Arising out of same FIR. The first is husband and second is father-in-law and mother-in-law.
Okay. Notice. Yes.
All 3 cases.
Much of this.
42.
Lordship, report pass over. No, after
No
launch.
pass over.
After launch, fixed matter. Lordship, both parties are present.
Compromise matter.
Lordship.
43.
On behalf of Mr. Mohan Sahu, he's on his legs. Kindly, my lord, pass over. Tomorrow, your
On
lordship.
the request of the counsel for the petitioner, urgent. Yes.
44.
Paper adjournment.
Urgent.
Both item 44 and 45 also.
Yes, Mr.
My case is connected matter. That may be adjourned, my lord, but keep it to 4th of July. In this case, Mr. Jaswant Das is appearing in this case engaged and has intimated to keep it for 4th of because the other matter is posted here.
Okay.
In the High Court, my lord. On that day.
Adjourned to 4th July. Since connected matters are posted on that.
Yes. 44 suppose, isn't it? 45 9 to
45 more. 45 same case. Jack ke panna jugal ke same.
44 na?
My matter is 44. Their matter is 45.
44, 45, both matters.
Okay. How many matters are there? 44?
44, 3, 4 matters.
4, 5, 6 matters.
Yes, 6 matters.
Okay, sir.
Entry
4th July.
Entry want to be continuous.
Want to continue.
46. 45 percent.
40? 46.
My lord, may I beg your lordship's pardon, my lord. In
Yes,
this
sir.
matter, my lord, I was arguing at length last time. Lordship, be kind enough to call for a CD and to ascertain whether there is material against the present petition. Apart from that, my lord, my humble submission that the OPID Act doesn't apply to the nature of transaction involved in the present case because the sale deed has been prepared, everything. So it is squarely comes within the prealum of PRERA Act. That is the clause, and this is covered by, if your lordship permit me, I must not venture that one of the Raspita Patra case is crystal clear in this.
That is pending in Supreme Court.
That is pending in this, but that is. And the preamble of the OPID Act is.
Rasmita Patra is pending.
Pending.
Yes. Yes, sir.
OPD matter, my lord, no counsel. OPD counsel.
Yes. Last time he was present and my lord was kind enough.
JP Patra. JP Patra appeared.
Yes.
But in fact, my lord, it's the name of B. Bhunia, my lord.
Patra Mr. Patra was last time there. Yes. Master appeared and
along with Mr. Bhunia, name of Mr. JP Patra may be reflected in the clause list. Release the matter. Yes.
There, my lord, I pray for my miscase for interim stay of the proceeding.
Interim stay without hearing of the other
But
side.
it was there last time.
We'll see. And 46th, na?
Yes, 46.
46. What is the stage?
Case, my lord, that the present
Cognizance is taken only. Only cognizance is taken.
yes, cognizance and the entire logical corollary, the entire proceeding. But quash the proceeding, so far this.
No, what is the stage of the?
Only after taking cognizance. Post
Nothing is moving. You move application if anything happens.
only, my lord, that will not.
Land counsel for the Mr. Mahapatra, land counsel for the petition submit that he would move appropriate application to court below, taking an adjournment going to the
Yes. Oblige, deep oblige.
Item 44, my lord.
Yes.
Sir is there, my lord, in the one some of the matters, my lord, appearing for
Fourth,
they taken time.
they have taken time, 4th July. They've asked for a specific date because some other matters are also missing.
They have absolutely there is no merit in the case. They are adjourning the matter.
That is the reason they are asking. And they say that you are busy in elections, so they.
48.
My lord, I am appealing for the informant. The matter has been compromised and both parties are present before this honorable court.
Compromise.
My lord.
Yes.
Affidavit, my lord.
Compromise now it is very dangerous.
Now they are afraid. After of that.
How many accused are there in this case?
My lord, one accused, my lord.
Prashant Das is one.
My lords, I am for the petitioner. This is the document showing that some higher offense has been added.
Sorry?
Some higher offense has been added. This is for kind notice of the honorable.
Higher
FIR was for 363 IPC, but
subsequently.
yes, subsequently higher offense.
Foxo and all.
Yes, yes. That is for.
Do you have 164 statement?
No, my lord, no, my lord.
What are the allegations?
For that is in the earlier occasion, we call for the 164 statement and statement, my lord. That has not been come, my lord. But in fact, the matter has been compromised.
What are the allegations? Those are in
though the FIR, my lord, the 363.
FIR allegation page 11.
363. But subsequently. Other lodged information, my lord, but
yes.
The problem is the petition doesn't say anything. Neither the 164 statement, nothing is, and in the petition, they see, nothing is said.
164 is not being available. That is the.
But in the petition also, you have not said what is the allegation, nothing.
The FIR allegation is there, my lords. FIR certified copy FIR annexed. Page 11 is the allegation.
Susmita Das. Madam, one number 161 statement is having, but I am reading 161 statement.
Of the victim.
Victim.
Yes.
More name Susmita Das. Mo bappa name so and so.
Case lordship.
No, 49, he is seeking adjournment because he is a government employee, because of the election.
No, my item is 50. 50. And the matrimonial dispute compromise is there and divorce is there. Already been held. So, lordship, the OP number 2 and the wife of the petitioner, and he is in out of station, and today you will not able to appear, lordship. And matrimony taken over after vacation. After,
yes, yes.
Adjourn.
51.
On request.
On behalf of Mr. Ekapanda, your lordship, let the case be taken after vacation, your lordship.
After vacation.
52.
My pleasure, lords.
Yes.
My lord, here in this case, my lord, during the my lord, mid of the trial, some accused person have been added, my lord.
319.
Yes, my lord. But they have been named in the affair. They have been named in the affair, but in the charge sheet they have been deleted. Some other persons have
Evidence might have come, so therefore 300.
they have been added. And that was, my lord, now, my lord, I have faced, my lord, here, my lord, the petitioners are those who have in the custody and facing the trial, and almost 50% has been examined. Now, my lord, my respectable submission is that, so the trial may, though they have been added, they have been initially added as an accused, subsequently, my lord, they have been.
Yes, what do you want? I know.
So that both the case, my lord, tried together and evidence will be recorded for both the cases. They have been committed, and from that is my only prayer.
Both the cases means?
Those who have been added in the 319, those who are, they have also facing the same trial. Same,
obviously, in the same trial only.
The same trial. So, but they are facing a different trial, different ST case. But my respective, so that should be together.
No, in the same case,
My lord,
evidence might have come with.
No, no.
Yes, my lord, because
lord.
they have been initially
My lord,
in the
I
affair.
understand here.
Yes,
my lord, what has happened? This case, wherein the petitioners are facing the trial, it is at the fag end. Only one witness is left to be cross-examined by the petitioner.
Defense.
So the case has been split up.
But
So
we are
that
in
will
custody.
be, no, maybe custody, if they are in custody and the trial will be ended, it will be beneficial for them. If they are not found to be guilty, they will be
Better idea, better thing for you. 2 opportunities you get.
And my lord, here,
Co-accused petition may be acquitted.
Yes.
Then you directly will get benefit.
my lord, because they have been named in the affair. Initial stage, initial allegation is against them. We have not.
232 रे
And your lordship, that was rejected on the.
ଏଇଟା ସରି ଯାଉ 232 ରେ ଆକାର ସରିଯିବ
And
trial face କରୁଛନ୍ତି।
ଆମେ trial face କରୁଛନ୍ତି ସେମାନେ ବି face କରିବେ ନାଇଁ ସେମାନେ ବି face କରିବେ ଆମେ ତ
That trial is in a very advanced stage.
Yes, almost over.
Almost no.
Yes, I am having the information. Only one witness. Only one witness is left to be cross-examined. Only one witness is left to be cross-examined. That is my lord specific instruction I have received.
No, my
From
lord,
the PP.
as per instruction.
I will simply say that age expedition is possible.
Yes.
My lord,
Yes.
my-
Yes.
and
Good idea?
Yes.
In view of the fact that the trial age against the co-accused persons are going on, so trial court will do well to see that.
Probably he has
not a single
My lord, that
other
is-
witness.
No, my lord.
One after another, how will I know?
My lord, your lordship,
So,
let me
instruction
clarify.
will
Let
be-
me
But a date book,
clarify.
I will take a
He is
instruction will be-
facing the trial in this case. That case is at the fag end.
No, my lord.
Yes.
Bystander
And
sacrifice
say that-
ହେଇଛନ୍ତି,
no, my
ଏମିତି
lord,
ହେଇଛନ୍ତି, ସରିଛନ୍ତି।
take care of- all the witnesses are all been examined except one who is to be cross-examined. The petitioners are facing trial in that case. Right now, they came before this honorable court and mentioning therein that the case which has been split up, that may be tagged to this and this trial may be stayed. My lord,
I am not, my lord, only praying the both the case together,
no,
not
no,
first trial.
no.
Put it
How
together.
he is
Some
agree-
of the witnesses are, my lord,
how
there.
he is agree
50 witnesses.
When it was splitted?
split up since long because my lord, 2019
FIR
issue.
is
FIR is of the-
FIR is 2019.
They have been.
Some of the, my lord, some of the accused.
Do you
were-
have any proceeding to say support your case? You show me the proceedings.
Beg pardon?
Proceeding of the court below. What is the stage and all? How will I know?
My lord,
You say something, she says something.
So,
How will I know?
next to Monday, I will take instruction, but no, my senior counsel is saying that that is not a fact.
No, that is a-
Then if you are contributing, you should be ready with your.
Let it come on Monday, my lord, I will, my lord, or tomorrow, my lord, I will.
Tomorrow midnight, no. How many matters I can take? Tomorrow bar is.
Monday, Monday,
You will not function after lunch.
Monday, my lord. What's it?
Tuesday. But come with specific
Yes,
instruction
yes, ma'am.
that what is this stage?
Yes, ma'am.
Then we can consider.
Yes.
53.
Mobilized.
Yes. My pleasure.
Yes, sir.
The petitioner challenges the other cognizance matter. Sure. Under annex, matter 3 matter. But the fact remains that the petitioner is the proprietor of Messrs. Chandan medical store matter.
It is arising out of.
260 case number 1 of 2018 matter.
But why have you not included the informant?
But it is the matter.
Complainant you should have.
The informant is the state.
No. Complainants.
Complainant is the drugs inspector. Man.
Anyway, you tell me.
Yes, sir. And on 2/11/2018 matter, the drugs inspector inspected the medicine store of the petitioner, wherein he found 47 pouch packets of loose tablets, along with other allopathic medicines for sale, and on wherein each pouch found 32 32 tablets of two different shapes. One is one circular biconvex and another is elongated biconvex. On demand, it is alleged that on demand, the petitioner are unable to produce any document of purchase of that medicine. Therefore, then another raid was conducted on 13/11/2008, wherein as per Rule 23, Subclause 4 of the Drugs and Cosmetic Rule, they have instituted the proceeding and case was registered under section by 2CC case number 1 of 2018. Wherein the cognizance was taken and the brief case record was transferred to the learning session judge, and thereafter he issued the appearance. The allegation is that I could not produce the purchase memo, and further there is an allegation that the two types of medicine which are found, one is circular biconvex and another is elongated.
What are your grounds?
Grounds is that
the case is made out.
Yes, madam. There is no conclusive testing report, madam. That is the case, madam.
That would be tested
And
in the trial only.
that is okay, madam. But madam, where no conclusive report, why I should be?
But there is a report. You will be acquitted.
Yes, madam. You could learn that. I pray for the appearance. There is a punishment of 5 years, madam.
Then what can I do? You indulge in. You don't have a ground.
No, madam. I have a ground. That is not conclusive report, madam.
Conclusive report
and allegation is
report. If the cognizance says, can I go into all these things?
Madam, the only allegation is that I could not produce
That's
the
enough.
purchase memo, madam.
That's enough.
Purchase memo, madam.
That's enough for cognizance.
Yes, madam.
You have found in possession of the drugs.
Yes, madam.
And
No,
you were confronted.
and there
you should have shown the
yes, madam.
purchase.
Another ground is that no valid license, madam. But not that I have no license, madam. I have valid.
Then transfer the petition to withdraw this petition to raise all points before the court below, and with this.
Till then I should be protected, madam. Otherwise,
What protection?
And no police action till that.
I am not entertaining your petition. When you question of court.
Someone
Someone is there, madam. I have
Someone can
annexed someone, madam. The appearance.
At this stage, however, counsel for the petition submits that he would appear before the court on or before 30th.
Be released on bail, madam.
2024 and seek remedy available to him under law. Till then, no course will be taken in. With this observation.
Yes,
30th June, I have given 30th June. I have given, go and appear.
I will appear.
No course of action till then. This much I can give you. Yes. Yeah. You will be happy with that. Yes. 54.
My pleasure. I'm challenging order for
Matter has already settled, madam. The offense on also 3 SCS and 5 procedures.
Where are they?
I am appearing this. Ravindra said.
3?
3 SCS 506.
रविंद्र कुमार सेठी आपण ना कौन आपण अच्छा प्रदीप कुमार मिश्र opposite party number 2 FIR number so came to be registered against the petitioner. The allegation against the petitioner in the FIR is that of phase 3 para 3. Investigation is completed.
Completed.
After investigation, charge sheet was filed on. Charge sheet was filed on.
And charge sheet of 19/4/2020.
19/4/2020, and thereafter the court of
cognizance taken. 22/4.
Session Judge Khurda by its order dated 22/4/2020
Yes.
In TR case number 192 of 2020,
Has taken cognizance.
had taken cognizance for offense under section so and so, so and so, so on. Page 16.
That is page 16.
Page 16. When the matter stood thus, the parties have settled the issue. Where is the affidavit?
Unnecessary 3. Single affidavit, joint affidavit.
The opposite party number 2 has filed an affidavit dated 3/3/2024 in Australia stating that due to misunderstanding arising out of a civil dispute between the petitioner and him, he has lodged the FIR. He doesn't want to proceed against the petitioner anymore. Take it up. Anymore.
Yes.
দুইটা affidavit কাই ফাইল করতে হবে?
দুইটা লর্ডশিপ জয়েন্ট অ্যাফিডেভিট
গোটা জয়েন্ট অ্যাফিডেভিট দিয়েছেন গোটা সেপারেট
সিঙ্গেল অ্যাফিডেভিট
And the opposite party number 2 has also joined with the petitioner to file a separate affidavit reiterating his stand. Petitioner and opposite party number 2 are present in the court, being represented by their respective counsel and identified by them. They have also filed the self-attested copies of their Aadhaar card to establish their identity, which are taken on record. Mr. Maharaja APS for the state and submits that in view of the fact that the parties have settled the dispute amongst themselves, and the dispute is primarily inter-se parties. Both the parties have filed affidavit before this court. The case of the there is no legal impediment in the FIR. Taking into consideration Gyan Singh and
Yes.
PCOC.
Yes.
Was. Yes.
Yes, my lord, challenge the order passed by the learned SDGM with regard to lacks of jurisdiction, my lord. That the OP number 2 is a contractor, my lord.
Lack of territorial jurisdiction.
My lord. My lord.
You say that all cause of action arose somewhere else.
The learned code below.
Page 23. Page 23.
23.
2-3.
Okay.
Yes. And the middle person on further perusal of the complaint petition in the middle. Order dated 10/1/2024.
Yes.
In the middle, on further perusal of the complaint petition, it is found that the date, time, place of occurrence mentioned by the counsel in the complaint petition as 1/7/2021 at about 12:30 p.m.
Toll plaza at Rajamunda.
District Sundargarh.
The construction work as
indicates that the occurrence took place at Rajamunda, which comes under Hon'Ble PS. Therefore, considering such facts and the circumstances, this court lacks jurisdiction to try the matter, and the IAC of a chain PS has very correctly written the 1cc case. So IAC is jurisdiction
the office, my lord, situated the petitioner's office situated.
The offense. Office might be situated.
All the transactions are made in that office, my lord. In my petitioner's office at Chen, which is situated.
Where is that transaction?
That is page 18, my lord.
18.
My lord.
18.
Sorry, my lord. That is page 17. 17.
Read out.
My lord. That is Basil Creation 2 Sri SK Das, civil contractor. S2H.
What are the allegations?
My lord, allegation, some transactions, the work has been done, my lord. And the opposite party number 2 has not paid 3,14,990.
সেটা ঠিক আছে স্যার আপনারা আউটপুট দেখুন লর্ডশিপ কাইন্ডলি সি
রিকভারি
পেজ 17 rightly point out page 17 for subject madam for lending of NH 23 New Delhi so and so just end Rajamunda section in the state of Odisha. So
yes.
Rajamunda coming under the jurisdiction of Sundargarh district
working
and under the Hon'Ble PS. So rightly
you are saying that he has not paid.
My lord.
The criminal cases are meant for recovery.
My lord, he has committed fraud, my lord, that's why.
Fraud, what you say that he has not paid after the work?
Misappropriated some amount. Misappropriated some amount, my lord, is the allegation.
That is why the court says that the jurisdiction is somewhere else. Go, liberty is granted. What is wrong in it?
Liberty has because that area is coming under the loan police.
No, the court says that go there. You go there. What? How does it make difference to you?
ଆପଣ ଲହୁଣପଡ଼ା PS ରେ କରନ୍ତୁ କିଛି ଅସୁବିଧା ନାହିଁ ତ ଆସୁଛି
ଲହୁଣପଡ଼ା କାଇଁ ଆସୁନି ସେଟା
ଏଇଟା ବା ଲେଖିଛନ୍ତି
ସି ଲେଖିଲା ଯେ ଆଫ୍ଟର ଇନଭେଷ୍ଟିଗେସନ ଆପଣ ଗୋଟେ ରିପୋର୍ଟ ଆଣନ୍ତୁ
ନାଇଁ IIC after receipt of the complaint petition IIC wrote a letter before the learned court below that this case is not coming under the jurisdiction.
The work has taken place there.
So that is why এবং ডাইরেকশন দেয়া হইছি যে
the transactions made at router.
Yes.
IIC is different. But transaction made at
are pertaining to this is a contract. Okay, this is a contract, and work was supposed to be carried out one place, and contract is taken place somewhere else. And after the work, the money was not paid. And what is the remedy? Civil remedy.
That is true because
Then you file one allegation of if you go to that, then on that ground I'll knock you out.
Because
how can you file a criminal case for recovery of not recovery amount arising out of a contract?
Cheating is there, my lord.
What cheating?
Because as per the terms and
then every contractor who works after a work order is issued, he will file a complaint case instead of recovery, instead of specific performance, instead of anything.
Yes, given some amount that has been accepted, that is because of that it has been.
Better you withdraw it. Better you withdraw it. An order is in your favor, better you withdraw it. When the counsel for the petitioner seeks to withdraw this present petition to avail remedy under law with this petition is disposed.
Small prayer man item 111, 112. Refusal is filed in late, can't be accepted. Refusal is filed in late.
Interim order is there.
No, man, no interim. Only issue.
Then oh, no problem.
111 and 12.
111 and 12.
No interim order.
Requisition opposite party filed belatedly. The same may be accepted and utilized for the purpose of.
Okay. Yes.
Item 61.
Back to patterns. Item 56. 61. Item 56 and 57. On mentioning time, some associate is taken time. Your lordship is granted after vacation. Only item 56 pray for Monday.
No, I don't.
It's very important.
Your friend has mentioned and taken the time.
Your lordship is not granted. What is release of vehicle?
No question.
57 is after vacation, but 56
then you speak to your friend. Why he has mentioned without asking?
No, your lordship is not granted time after vacation. Your lordship posted for after vacation.
I have already posted.
57 is after vacation, but 56 is very urgent. Release of vehicle, your lordship. Monday, Tuesday.
Then your friend mentioned what to do. I'll have to believe your friends.
He mentioned for
yes. Item 58 last occasion I received a hard because I have not met the informant as a party, who is my wife. I have made him here a party. There notices to go, my lord.
15 or 16.
If your lordship will please to hear it before long, then I have to go to attend marriage of my clerk.
Definitely. Definitely. Marriage must go. Issue notice to opposite party number
52. My lord, I have consolidated cost title I have filed already.
Yes.
Opposite party no 2, my lord.
2.
Because investigation said there is no necessity of
only prayer
issue notice written.
Only prayer item 56 no let's see item 56 only, not 57. Item 56 pray for Monday or Tuesday any day.
It can't be, sir. Somebody mentioned, how can I help
mother
you?
Is very illness. Your lordship senior will agree the matter.
May I mention item 61, my lord?
Yes.
Lord, item 61 is connected to criminal MC 1300 of 2024. Your lordship said stayed the trial proceedings. My lord, the same order I'm requesting. It's come up for the first time today. Criminal MC 1300 of 2024.
66. Item 60.
61.
What do you want?
Lord, I'm saying lordship may attach this matter with criminal MC 1300 of 2024. And the order which my lord, my friend will be
61. Private party 61.
23rd of
61.
I can screen share the order. Lord.
So this I will take it up. I'll take it up from
Lord, I have All right, my lord, I'll come, but I had a matter fixed for 2 in where I
And your friend is completely armed. Don't worry. Even if you are not there, he'll do it. I'll
So
take
great,
it up.
so grateful. So
Any
grateful.
adjournment, anything, then it's all right.
All right.
I'll take it up. Don't worry.
All right. my lord.
Yeah.
Your Lordship, I have asked to file the note by today, ma'am. Qualifying as well to time.
No.
Pattern, my lord, item 110. After vacation. The instruction, what instruction was, they change the complete.
110.
110.
One defect is also there. Remove kar. Again, what a defect is remove kar.
Yes.
One defect is remove kar.
Item 42.
42.
My lord, the petitioner challenges order of cognizance.
No, 42 settled, huh?
Yes, your lordship. They got married and
Both are got married, man, and they blessed 2 in child.
Okay. Pokso is there.
informant is the wife, my lord. Due to matrimonial dispute, subsequently, my lord, they both have arrived and
Your Lordship, may kindly see the page 30.
13.
30. 30.
No, come to the impugn order first. This is
Annexure 1.
Section 12 on to section 8. That is the alteration. Charge alters from section 12 to section 8. Page 51. Page 51, last occasion also. I have already.
Show me the
51. Page 51.
51, huh?
Yes. Last line.
Yes.
Hearing the shout of my father.
1 minute.
Minus 5. That will also.
Yes.
Yes. That is right on.
Yes.
That's what it 51.
Yes, I got it.
Last page. Last line. Yes.
I raised to the
yes. Only
Bari,
because of this charge alter.
Bari caught my hand.
Yes.
And dragged me with evil intention. When I raised Hulla, my father, who was in front of the house, came to Bari. Hearing the shout of my father, Manas preferentially forcibly gave me a kiss and left.
That is why turn to section 8.
But Your Lordship, CAG also stated in the 161 AG, the page 30, in which she stated that more Namo Nirupama Raut, Pitta Sudarsana Raut, Gramo Siko, Thana, Rajkonika, Zilla Kendrapada. In the sentence.
Where are you reading?
May kindly see.
Which page, madam?
Page of 30, 30. 161 statement of the victim girl. मोर मौखिक जमानबंदी यही जे मु कमला मॉडल बालिका उच्च विद्यालय रे आयतन रे 10वीं श्रेणी रे परीक्षा पास करिबा परे घरे थिली टंका पैसा अभावरु मोर बापा मते अधिक पाठ पढाई पारले नाही गत ता 6/3/2022
300 of 2024. Lord, my friend will just place before your lordships the order which was passed.
This is in respect of the second accused only. Same offense, same complaint,
Same impugned order.
Everything same.
Everything is same.
I think case number 32 of 2023. There are two issues. Two issues have been the petitioner is erased as one of the accused, along with one Mr. Chitaranjan Das. Chitaranjan Das had filed the CRLMC number 1300 of 2024, which is pending before the court. While the order dated 23/4/2024, this court has passed the following up. In case of Chittaranjan Das, following up in case of Chittaranjan. Okay. In view thereafter, what is the entry order?
Not stay up for the proceedings, stay up.
Issue notice to the opposite party, number so and so, and in the meantime, further proceeding is already stayed.
Yes,
in respect of that individual.
Right. Further proceeding in ICC case number 32 of 2023 pending in the court of James Asuda, the state
After vacation then.
vacation after.
I guess. Deep blue.
Yes.
Around 48.
Yes, 48.
Conclude the proceeding, which is pending, similar proceeding which is pending before the JNFC Kendusha.
Speak little louder. What is the problem?
Sir, his prayer is for conclude the proceeding, the trial. And out of 48 charge sheeted witnesses, last witness examined on 11/1/2024, that is witness number 26.
Petitioner
So it is
seeking
going on. The trial is going on.
disposal of the trial, a trial in the arising out of PS Ghottagaon PS case number 18 of 2021. Mr. Maharaja then comes for the opposite ADA states that in the present case out of
48 charge sheeted
witnesses,
total 26 witnesses have already been examined
26 witnesses have already been examined
till 11/1/2024.
till 11/1/2024. Yes, the trial is proceeding at the expected pace.
Yes,
Therefore,
continue.
no direction as such is required. Hence, the petition is disposed of, and it is expected that the trial court shall do well to see that the trial is concluded as expected.
Yes, yes,
yes.
65. Can take no after.
Dispose of.
65 can take no after vacation.
Vacation. Okay.
66. 66 Belgium matter, my lord.
Yes.
Petitioner was granted bail in the year 2015, and the NBW was issued on 22/2024.
500. Yes.
Oblige.
Yes.
68. Matley.
A petition challenge the order in the learned court below, rejecting the application for leave the freezing of the account. Leave freezing of the account of the petitioner. Now here, on the basis of false case lodged by the brother of the petitioner.
Who are you? You are accused.
I am an accused. In this case.
Yes.
Dispute is like this. My brother lodged this affair. He alleged that the compensation amount, his share has been credited to my account. But as per order under Annexure 4 passed by the land acquisition officer, that is 6/1/21. Order dated 6/1/21, page 28. May I read those?
Yes, tell me what happened.
In
Section 31 application was moved.
Pardon, Lordship?
Section 31 application before the trial court while
Yes.
disbursing land acquisition money was moved or not?
That was resolved, my lord. That was resolved of all the brothers are get their appropriate share. Then you know, after some time, he lost this case, affair that some my share has amount of my share has been credited to this petitioner.
What is the amount?
Amount he said, my lord, 1 crore 50 lakhs something. Yes.
What do you say?
My lord, this is clear order. It is there.
Okay, it's brothers, na? Who will issue
Notice.
notice? You have not implemented. What is it?
Listen, kindly see.
What I will not see. Where is your brother's name?
Party ko naam.
Party. Only defreezing my account. So that's
You
what-
have to implead him as a party.
But he, more than his share he has taken.
You want a
Yes, ma'am.
you want an acquittal order.
I may be permitted.
You want an
I'm
acquittal
sorry.
order. I'll file a acquittal order.
I may be permitted.
Implead your brother. There is some money dispute. We'll sort it out. What is the big deal?
Yes.
Implead. Let counsel for the petitioner seeks leave of this court to implead the informant.
Yes, ma'am.
As opposite party number 2. let him do so during the course of day, countersigned by him, and issue notice after him, issue notice to opposite party number 2, written evidence also. Yes.
70.
Do it right now. File the requisite.
That may be because my old age pension is being credited to that account.
Not date on immediately after vacation.
Yes, ma'am.
Yes.
70.
70, yeah. Your Lordship, please. Here, Your Lordships, I challenge the interlocutory order dated 4/4/2024, wherein the learned magistrate rejected my recall petition under 311 of the Code, my lords.
Who are you? You are accused.
No, my lord, I am the complainant. I had filed the complaint case. If Your Lordship sees Annexure 1 for a moment, my lords, there is at page 10.
Where is that impugn order?
Pardon, my lords?
Impugn order 4/4.
At page 10.
Yes.
Annexure 1.
What is the reasoning?
Lordship. Lord sees page 11. The orders
Yes. Right.
later. That order, my lords. The order arises out of a petition under section 311 filed by the complainant with a prayer to recall PW1, my lords.
Who is PW1?
The accused. The complainant submitted at the time of filing of this case. Inadvertently, learned counsel has tagged the demand notice of another case and the same was marked as Exhibit 4. Hence, the complainant played to recall the PW1 to again prove the correct demand notice. The Lordships, what had happened here is that 2 1cc cases were filed alleging dishonor of 2 checks, my lords. One, my lord, for a sum of rupees 1 lakh.
Out of confusion, you file.
Yes, it was interchanged between the 2.
Issue notice.
Issue
notice.
71.
71, not on behalf of Mr. Anuragpati, I'm challenging the impugned order, which is at Annexure 3, to the extent with regards to the condition 1, which is, my lord, at page 49, my lord, the case pertains to what happened here was that the
What condition? You have granted bail?
No, my lord, not bail. My lord, under 457, it is related to defreezing of account. So what has happened is
Which condition?
My lord?
Which condition you are agreed?
My lord, the amount of 3 lakh rupees, my lord, which has been imposed, that is at page 49.
Withheld 3 lakh.
My lord?
3 lakhs to be
Yes,
withheld.
yes.
Withheld.
Yes, my lord. That is the condition, my lord, I am agreed with. And in the seizure list also, there is no, the checks have not been, my lord.
How much is the balance in the account?
My lord, it is less than 3 lakhs. As per the instructions that I have received, my lord, it is less than 3 lakhs. So that is why to that extent, my lord, I am aggrieved that the amount of 3 lakhs has been withheld.
What are the allegations?
The allegation, my lord, here is that the complainant, my lord, which is a construction company, they had then, I was the director. Now I am the director. Now they made allegations that I had siphoned off or I had misappropriate funds to the tune of rupees 20 lakhs. And my lord, an FIR was registered against me, which is at Annexure 1.
At whose instance?
My lord?
At whose instance?
My lord, at the instance of the construction company, my lord, I was the director. So it is Mr. Naveen Agarwal and Mr. Sibo Sankar Mishra and the...
Who is the informant?
My lord, yes. The... Well, it's the company. Just a minute. Please.
71 tha?
Huh. My lord, Mr. Naveen Agarwal, my lord.
Shankar Lal Agarwal.
Shankar Lal Agarwal, my lord, is the father of Mr. Naveen Agarwal, your lordship.
Implicate Naveen Agarwal.
Naveen Agarwal ki party na.
Then, my lord, may allow me, my lord, I'll file an IA. And...
I'll issue notice to implead, huh?
My lord, my lord. Deeply obliged.
Counsel for the petitioner seeks leave of this court to implead the complainant.
My lord.
As opposite party number 2, during the course of the day, he may do so, countersigned by issue also. Issue notice to opposite party number 2. Mr. Maharaja accept notice for 1. Written level. Yes. Next.
Extra copy, sir.
Extra copy.
Yes, sir.
Yes.
72.
Legal lawsuit, my lord.
Yes, sir.
Here, my lord, application under 311 was rejected. Against that, I have come up with lawsuit.
You are accused.
I'm the accused, my lord. 4 accused persons are there. Offense under 307 and 120B IPC.
Which witness you want back?
My lord, victim himself, my lord, because victim was we had examined, but there are certain questions we have already formulated questions, my lord. May kindly have a glance to Annex 4, my lord. At page 29, my lord. 3 questions we want to put to victim. And 2 judgments I have cited, one for Hon'Ble Apex Court, other one for this.
Date of judgment, PW 12.
PW 12, man.
Come to his deposition.
Yes,
Whether
ma'am.
you have put those questions.
No, those questions have not been put, my lord. I have vividly tried to find out whether those questions have been put or not. Particular questions,
Yes,
they are,
Mr.
he has already answered.
Give a single opportunity,
Yes,
307.
yes, your lord. That is only.
Victim.
307.
Single indefensible right.
Yes, sir.
Head on. Petitioner is agreed by the order dated 23/4/2024, passed by second additional sessions judge Rahul Kala in ST case number 179 up to 179/02 of 2012, whereby his application under section 311 CRPC for recalling the PW 12 oblique the victim oblique the injured has been turned down. In the application, petitioner has in the application under section 311 CRPC, petitioner has enumerated the proposed questionnaires, and the petitioner has also filed the deposition of PW 12 as annexure 3 to present petition. Perusal of the deposition indicates that the question, proposed questions to be put to the witness has indeed was indeed not put to the said witness. The Learned Court below has rejected his application. Petitioner, since petitioner is facing trial for a grievous offense, and he has a indefensible right to defend himself. Therefore, the application under section 311 CRPG moved by him ought to have been allowed by the court. For the foregoings, the present petition is allowed. The order dated, the impugn order dated 23/4/2024 passed by so and so is set aside. Which court? The learned the second sessions judge Rahul Kala is directed to afford a single opportunity to the petitioner to examine PW 12 on the date to be fixed by the trial court, and it is made clear that no adjournment shall be granted to the petitioners on any ground.
Yes.
On any ground. Before the PW 2 is subjected to the cross examination, the trial court is also directed to analyze the relevancy of the questionnaire to be put to the said witness. With this observation.
P12, actually, what happened was just one line mentioned in the order, my lord. Case put up on urgent to 29/4/2004 or argument, my lord. Whether that has been 29.
I have filed it on 6th May. I have filed 6th May.
Whether it is over or
no, it is not over. Had it been over, I have filed on 6th May. I have filed this petition because this
April मासरे थिले
argument में थिले मो आजी मेरा मई मास फाइल करती
the outset सबसे बोलो the outset Mr. Ragada AGA submits that the trial was at the fake end, and the matter was fixed for final
argument.
On which side they have choice?
Argument. To this, Mr. Shobhagya Das, for the petitioner, submits that the trial is still going on.
Yes.
It has not yet been concluded. And he pressed the present petition.
Yes, sir.
Yes, sir. Yes.
At your yes.
73.
Yes.
In the instant case, my lord, the FIR was filed, my lord, on 120B of IPC, 40CA of UAP Act, and another 17(2) of CRLA. And after charge sheet, my lord, 121A was inserted, my lord. My lord, in the instant case, they have dismissed my 227 application, my lord, and I'm also challenging the cognizance order on 3 grounds, my lord. My lord, first is that before taking cognizance, there was no sanction, my lord. This is the first ground of challenge. And second is that the SI, one SI Abhimanyu Pradhan, who has lost this FIR, my lord, he had taken up the investigation. As per under UAP Act, not below superintendent level of police who take up the investigation. This is my third
What are
ground.
the offenses?
My lord, offenses are under 120B, 121, 121A of
Unlawful
IPC.
activity.
Yes, my lord.
Your lordship, may kindly see in the prayer, my lord,
My
the
lord,
page
another
15.
Third ground.
Okay.
I have not.
No, this ground is there, Jana.
Yes, my lord.
That,
My lord, how gote hochi je NIA Act re
in UAPA, it's not like UAPA investigation has to be carried out by a officer of a particular
Yes, my lord.
level. Has it been done?
I don't know, blood, what are the documents, but I have find in one application, 2 order have been challenged. One is cognizance, one is discharge. Prayer is to quash the cognizance and to quash the discharge petition. It is not permissible. Then I am coming to the discharge. Page 75. Page 75. It is a case. The finding is para 3rd. Here is the case record so far as the ground taken by the London Defense Council regarding a defective investigation is concerned. It reveals that the charge has been submitted by the Utkal Ranjan Das, who was the then SDPO.
My lord, can I have a glance to my lord? Kindly have the Caesar report, my lord. Kindly have a glance.
No, what happens, I'll tell you. You
Yes.
see the judgment.
Yes, my lord.
It says that if the statute says that a particular level of officer has to investigate,
Yes,
that doesn't mean that he can't get the assistance. Suppose 161 statements are recorded by his junior officer. Ultimately, the charge sheet has to be filed by him.
He has to verify.
Generally happens. Senior officers employ their own junior officer.
Yes.
My lord, what
Get the work done by them and file the charge.
My lord, what about the sanction?
And
my
it's a case.
My lord, my lord, as per the Bikramjit Singh case, when NIA Act came into force, can a SDGM rank of my lord, they can take up the investigation. My lord, my cognizance order has been taken up by one SDGM court, my lord. Kindly have a glance to page 78. My lord, as per Bikramjit Singh, this is a specific act.
You are right.
And he has no authority or jurisdiction to take up the cognizance order, my lord.
So it needs
And my lord, in the
it
similar,
needs consideration, Mr.
my lord,
Maharaj.
my lord, in the similar case
Yes.
also, your lordship, he is also one of the accused in
I'll
this
take
case.
instruction. Yes.
Accused also in this case, my lord, your lordship has notice and my lord.
My lord, another thing.
Same affair, my lord. I have given the cover page, my lord. 45/8.
This same another accused.
Yes, my lord. Kindly have a glance to page 19.
See another
The name
accused.
of-
This is the order pass.
Yes, my lord.
19.
Have you
Yes,
seen?
my lord.
Matte gote copy.
There you go.
Same affair.
Actually, this slot is Mr. Hon'Ble. He was absent. I don't know. I have not read the entire case. Only I am managing this.
Now, I'll tell you in that matter, in the same FIR, another accused. In that matter, first I issued notice on 13/2/2024,
Yes.
where I said that Mr. Maharaja seeks
Yes.
time to obtain instruction
Yes, yes.
as to whether before taking cognizance of the cognizance by the trial court below, Was the sanction obtained against the petitioner to be prosecuted under UAP Act?
Sanction
And
has been,
thereafter-
sanction has been obtained. I have stated before Lordship last week, it was listed, this matter was listed before this honorable court, and I have stated that sanction has been written in the charge sheet, has been specifically reflected that sanction has already been
In this
taken.
case,
In this case.
charge sheet is okay.
Yes, on 4/3 of 2023.
Whether this matter is disposed of now?
No. This is pending and your Lordship directed, it will take some time. As counsel for the petition submitted, it will take some time. That is why, no, I'm not saying you. So he adjourned this matter last week. Adjourned this matter.
Lord, that is also.
Issue notice check with this.
Yes. I have
Issue
said.
notice check with this matter.
And the entire record is in that.
I'm
So-
issuing notice
so can
check
it
with-
be-
in
can
any
it be
case, there is
tagged?
an entry order, it will be adjourned.
Yes.
You will move application for adjournment.
Yes, my lord. For
And
adjournment,
this
then
record
that
may be
will
tagged
be-
with the serial remediation number 4343 of 2000.
Yes.
Yes. It will be better.
Yes.
An adjournment, if I'll
Adjournment.
be praying for adjournment, that may be.
Tag with that last paragraph. Tag with this last paragraph is also that is also for the petition, move application.
Grateful.
Yes.
74.
Item 74, my lord, kindly one pass over, my lord.
आज ही पास होता
One pass over.
How about it?
75.
May plus 75 and 76 both are identical. But I'm challenging the notice manual under Annexure 1, page 8. Page 8 manual. Now
110 notice.
110 notice on the actually the written manual substance of allegation while issuing the notice to file show cause that has not been reflected in the notice, and particularly the executive magistrate committed error directing me to the file bail bond with the surety who is a government servant. That cannot be.
Mr. Maharaj.
My lord.
Yesterday I passed some order.
Yes. Mr. Jana case.
We give the number, same order.
Same number that you give them, same order good.
75 and 76.
Same, he had the same government surety. Where from will government surety?
And a written note of substance must written allegation of substance. Yes, ma'am. 75 and 76.
Please take the number. Okay, allowed.
Say it a little.
I modified that condition.
And apart from that, factual error is
go and give bond.
Yes, obliged.
77.
Yes.
The proceeding under section 132 NIR.
Where is that number first you give? Then you will evaporate, will keep on searching you. He is busy lawyer, he will.
I'm supplying also.
You are very busy, you will evaporate.
This was not in the list. This is not in my list. That is I undertake to give supply alerts.
Yes.
Yes.
What is this matter?
The 130 day NIC lordship, here I am the accused and the opposite party is the complainant lordship. The complainant while filed the complaint case has not been filed certain documents. After he examination lordship, filed certain documents before the court below to mark it as exhibits lordship. So I filed an objection. My objection was specifically that this was not filed in course of the complaint petition and in course of examination he has.
Let me issue 138 matter. Issue notice to opposite party. Let him come on. What is the check amount?
Issue, I guess state
Check amount.
check amount let's see. 2,36,000.
घर की पड़े तो खत्म कर दो एक अमाउंट नहीं आया तो खत्म कर दो
I will take instance till then stay alerts.
Legal counsel for the petitioner seeks to submit that he would move appropriate application before the court below seeking adjournment owing to the fact that the matter is of
Obliged.
78.
get by installment pay. Take the number 75 78 na?
In this case number 1,441/2024.
ठीक है
1,441/2024 it is disposal. 2014.
14 ଥିଲା 144 by
144 by 2024.
Yes.
Deepak Chattar.
Next,
78.
78, may I please, Your Lordship?
Yes.
So this matter arising out of the same FIR from the previous case. The notice was issued to the individual.
Same FIR, different accused.
Different, only the family members.
FIR. ICC case number.
1CC case.
Issue notice. Tag with this.
Your Lordship.
992 of 2024. Tag with 992 of 2024.
Grateful, my lord.
Yes.
79.
79, my lord, here the very limited prayer of the petitioner that petitioners are the accused of sessions case. The prayer for early disposal of the case because I have stated in my petition there are 18 witnesses, out of which 10 has been examined, and in respect of 3 witnesses, they are the family members of the deceased. They deliberately not coming even after the issuance of bailable warrant, and the court is not also taking any
Let us
step.
see what is the status. Get the status.
Get
of
the
that. Issue notice. Mr. Hon'Ble appearing for the AAG, and it's time to get the status of the trial. Yes.
80.
Even I have given the last order sheet, your lordship, page 43.
Anyway, let him bring.
6th of April.
Next time I will allow. Okay.
80.
Lordship, order of cognizance passed by the Lord Legislative Hindu.
Huh?
Order of cognizance passed by the Lord Legislative Hindu under section 498A, 506, 34 and 4 DPR is under challenge, your lordship. And I am challenging this order of cognizance on 2 grounds. One is decree of divorce has already been passed by the judge family court. When there is no more husband and wife.
1 minute. Issue notice to opposite party number 2. Returnable. Yes. Let them come. 498 finish it up. Yes.
Lordship, I for stay because they are issuing summons for appearance.
So appearance 498. What is the big deal?
Lordship, all the relatives are there with all of them. Some of them are working outside.
No, you talk about yourself. Who are the petitioners?
Petitioner, sister-in-law, husband's sister. Sister-in-law of the informant, your lordship.
Bangalapur, Jajpur. All are Jajpur resident.
But they are residing at present, they are, your lordship, government servant there, all of them.
What is same for this? Pray for adjournment. We to go. Yes.
No. 81.
Yes.
Matter relating to bails of your lordship. The present petitioner filed a religion bail on dated 18 to 16, and due to wrong noting of the conducting council,
18 to
2016.
Oh, what is also
And NBW was issued.
Okay.
Your lordship, on behalf of Mr. Equipment.
500. Yes. Next.
82.
82. Yes.
May I please, Your Lordship? It's a Belgium matter, my lord. The petitioner was released on bail on 5/11/1996, and the NBW issued on 7/4/2007.
1000.
Good.
83.
Belgium matter
9/1/2017.
83. Yes.
Belgium matter during trial, witness Hon'Ble did not appear on that day.
No, you
So-
you are on bail.
He was on bail in 2012, but I didn't.
He was on bail. Huh? Bail. NBW issued on
NBW 9/1/2017.
17. 1000.
84.
Belgium matter. Petitioner on bail on 5/12/2022 meters. NBW was issued on 7/11/2023 meters.
500.
85.
Lordship, on behalf of Mr. Ekapanda, your lordship, quashing of the NBW, your lordship. I was on bail, your lordship. The bail order is annexed with annex
Date
of
date time nahi.
Date.
27/3/2020 ବେଲ ଗଲେ 25/2/2023
Again, sir.
27/3/2020 ବେଲ 25/2/2023
25/2
15 লেখা ହେଇଛି 15/2
15/2
15/2 ଲେଖା ହେଇଛି 15/2/2003
15/2
Sir, 15/2/2023.
15/2 ঠিক 500
86
Apply.
86 Belgium mediation. Envelope has been issued on 5/9/2022.
2020
22 5/9/22.
5/9/2022 bail
Bail perhaps on different occasions. They are on,
Huh?
on the different occasion. I have one so only one bail order, but both the petitions were on bail.
both the petitions are on bail got 500 each
87
Belgium matter. Bail granted on 5/10/2016. NBW issued on 10/7/2019.
500
88
88 Belgium matter. NBW issued on 27/2/2024. Prior to that, the petition 27/2/2024.
bail
Prior to that, the petition was on bail. I am not.
on bail ठीक 500
89
Belgium matter, let's see, bail on 3rd March 2023. NBW has been issued 2nd March 2024.
500 you check the file out
80.
yes
90
No, 94 more. 90. 90.
yes
The Belgium matter, the bail is allowed 10/8/2021.
10/8/2021 NBW 2324 500 yes
91
Bail on 27/1995. Bail. NBW 27/99 and thereafter consequential NBW.
99 is a NBW rate.
No, NBW 5/2/1999 ହେଲା NBW.
Yes.
Bail ହେଲା 20/7/1995 ତାପରେ 80 to 83 NBW ଅନୁସାରେ ବି କରିଦେଇଛନ୍ତି ସେଟା 14/2000
2000 oh 1000 ठीक
92
Petitioner was on bail 21/4/2016 and NBW issued 2/8/2021.
Yes.
21
Yes.
500
93
Belgium matter, your lordship, NBW was issued on 6th April 2023, 6/4/2023 and bail he was
19/4/2006.
19/4/2006.
94
Lordship, this petition is for caution of the NBW. And he has been released on bail on 5/9/2017. And NBW has been issued on 18/11/2020.
2023.
500
95
95, my lord, on the prayer of the IO, the NBW was issued prior to submission of charge sheet, my lord, on 29/11/2012.
prior to submission of the charge sheet and the request of IO NBW was issued on
29/11/2012.
1000 yes
My lord, he was not on bail.
As per. Yes.
1000 go and get the bail
Yes.
My lord, lordship may direct me to surrender on a particular.
yes yes
30th June.
30th June
Till then,
no court
obliged.
96
24/3/22 he was released on bail. The warrant issued on 25/23 minute.
sorry
24/3/22 ରେ ହଉଛି bail.
25/8/23
25/8/23 ହଉଛି
warrant.
500
97
My lord, it's Belgium matter. The petitioner was earlier on bail on dated 7/9/2012. NBW was issued on 25/1/2024.
500
98
NBW 15/3/2024. Bail 36/2022. 36/2022. 36. NBW 15/3/2024.
500
99
yes
Bail on 9/2/2024 and NBW on 15/4/24.
500
100
NBW issue on 26/4/2024 and 41/24. And then 41 the petition 15/4/2021 million.
41 yes 500
101
My lord, NBW on 17/8/23 bail was 14/10/10.
NBW
17-8-23
500.
my lord 27% your lordship may direct
27%.
my lord all are tribal persons
How much you will pay?
my lord
How much you will pay?
Be-
5,000.
NBW 17-8-23 my lord
How much will you pay as a cost?
and total my lord 5,000
27 people.
my lord 5,000 they are Adimis people my
So
lord.
5,000.
102.
The Belgium matter, your lordship, petitioner was earlier on bail on 4/4/2022, your lordship. Then the non-bail warrant is issued on 8/2/2024. 8/2/2024, your lordship.
8/2/2024. You are not taking lunch.
Yes, sir. 8/2/2024.
Huh?
103.
The NBW is on 17/6/2016. Bail date is not given.
On bail got them. 1,000.
104.
My lord, Belgium matter. Bail entered on 22/7/2023. And NBW entered on 25/4/2024.
105.
May I please your lordship, my lord, cancellation of bail matter, my lord. The IIC first filed an application under Annexure 4 before the learned court below, my lord. The 10 cases are pending against the accused persons who are the opposite parties 2 to 4 before your lordship. And while on bail, again they have committed offense. And another PS
You
case.
tell me whether they were in bail or not. I
Sir,
don't want to go
they were on bail.
He was
and
on bail.
While on bail, they have again committed the offense.
It's all right. You won't appear. NBW was issued. He was
No, my lord, cancellation of bail matter. This is, my lord.
You want cancellation of bail?
My lord.
Okay.
Notice is to go, my lord, 2 to 4.
Was there any condition that they will not commit any?
Yes, my lord. Condition, they shall not commit similar type of offense.
Okay, issue notice. Next.
106.
But may kindly fix the
Date.
Grateful, my
May I
lord.
please your lordship?
Yes.
May I please your lordship? My lord, the petitioner filed this petition for modification of order of the for modification of bail condition.
Which condition?
The Lawrence ADJ, additional session judge, granted bail to the accused.
Condition. Which condition? Condition number?
Conditions are 1,000. The accused will be punished.
Are you just tell me you are agreed by which condition?
Order passed by the Lawrence additional session judge Kendrapara.
I know, I understand that, but there are 4 conditions. You are agreed by which condition?
Alright, he's challenging that Roman 1, 2, 3, 4 is that the paragraph above
10,000
that.
security with
1,000
cash
rupees
security
only, cash security
2,000.
2,000 and bail bond of 10,000. He's agreed by that.
Bail bond? 10,000.
Bail
10,000.
bond,
He's agreed by that.
2,000.
Your lord.
bail
That
ଦେଇ
is
ପାରିବନି
challenging.
ସରି ବୋଲ bail
2,000.
ଦେଇ ପାରିବନି cash security ଦେଇ ପାରିବନି. I am appearing as a deputy chief legal aid defense counsel. Sir, ଓକିଲ ଦେଇପାରୁନାହାନ୍ତି legal aid counsel ଦିଆଯାଇଛି ଆଉ ବେଲର ଦେଇପାରୁନି କି cash security ସାର୍ ଦେଇପାରିବେ. ସେଇ ପାଇଁ ସାର୍ ସେ ଦୁଇ ଅଛି ସାର୍
See the condition.
28
2,000
to
rupees also he is not able to pay.
But he's appealing for legal aid counsel also. Therefore, your lordship may consider.
Wait, petitioner is agreed by the condition imposed by the court below while enlarging him on bail on 19/3/2024. He is agreed by the condition that he need to furnish cash security of 2,000 and bail bond of rupees 10,000 with one solvent surety of like him. He seeks the petitioner seeks variation of the condition. Taking into consideration the fact that the matter is the it is taking into consideration claims, since it is a illegal aid matter, the petitioner is not able to furnish the bail bond or the care security. He was not able to avail the benefit of bail. I waived the condition so imposed by the court below and direct the HCGM Kendrapura to suitably modify the condition. Suitably modify the condition. With this observation, petition. Yes.
Pardon, my lords. Item 48 regarding payment of compensation, my lords, that has been complied and memo has been filed. Yes. Money has been given and memo has been filed before the court.
107. In this case, the proceeding has been stayed on 26/11/2018, my lords. But the summons has been issued for personal appearance of the government officers, my lords. On 35.
Stayed by this court.
My lord. Subsequently, it has been on 10/3/2023, it has been extended. And subsequently, 19/4/2023.
Till next date, it was there.
My lord. Also, 19/4/23, the LCR has been called for. That has not come, my lord. Now the on 19/4/2023, this honorable court directed for a call for the LCR, my lord. Till that, the LCR has not been received. All of the petitions are the government officers, and they have relocated 120 families. Now the petitioner, the opposite party, no one signed the resolution.
There was stay at the trial court.
Yes.
See, 26/11/2011, 18, stay order was passed. Subsequently,
Subsequently, 10/3/2023, it has been extended.
where is that order?
The order dated order 5, my kind listening.
Huh?
Order number 5, my lord.
5.
My lord.
Yes.
Extension. So the extension is time down.
10/3/2023, my lord. 10/3/23, my lord. Order number 5, my lord.
Till the next day, 10/3/2023.
Subsequently, 19/4/23,
Set up
the
must stay continue.
LCR has been called for.
But here the entry order was not extended.
My lord.
That is the reason.
My lord. Now the judgment on the stay order is not required, my lord. So the extension of stay, my lord. But
you tell me what is this case is about?
That is regarding a relocation of the 120 family from the core area of the forest.
Where is that? Where is the order by which NBW was issued?
That is Annexure 6, my lord.
You are challenging this.
And questioning of cognizance, my lords.
Arranging out a complaint case.
Arising out of complaint case, my lord.
No, you say that there is some order passed now.
Someone issued.
Someone issued, my lord. Someone
Since
is
stay
there.
has not been extended for that reason, my lord, issued this. Lower court rightly, my lord, issued someone.
Someone issued. What is the problem? We will examine this issue.
But the LCR has not come. This honorable court called for the LCR, my lords. So that has been exonerated on 2000.
Right on 26/11/2018. Why this matter is pending for such a long time? I don't know. On 26/11/2011, this court, while issuing notice to the opposite party, have stayed the proceeding in ICC case number 75 of 2018, pending in the court of LCGM. Karanjia. The said interim order has been extended time to time, and eventually on 19/4/2023, this court has called for the record, call for the trial court record.
My lord.
Call for a status report from the court below. However, on that day, it seems the interim order was not extended. Hence, the trial court by order dated. Where is that?
Someone tell me.
Order dated 3/5/2024 has issued summons to the petitioners. Summons to the petitioner. The petitioner is
For the person,
petitioner is agreed by the same. Adjourned, matter is adjourned to for hearing. The interim order pass on 26/11/2018 shall remain in force till next day. Yes.
Beg your pardon, my lord. 103, my lord.
103?
Item 103.
Long way.
Belgium matter.
Belgium
Court nata ticket. The case record.
In every matter you have problem.
Mala ticket, sir. Athagadu bottom.
I don't know. In every matter you have some problem or the other. Either case number is wrong.
No, wrong
number
है
is wrong.
Wrong है नहीं sir.
Wrong है तो जा दो.
जो NBW जो इश्यू करथिले बर्तमान केस रेकॉर्ड आगु गोटे कोर्ट को ट्रांसफर हे
103 दे दो यार. चेक कर दो.
रेकॉर्ड रे भूल नहीं सर. रेकॉर्ड रे कुछ भूल नहीं.
Course रे कोन
कोर्ट केस रेकॉर्ड टा आगु गोटे कोर्ट को ऑलरेडी ट्रांसफर हे.
How do I know? How do I know? I have to go by record.
ଆଜି ହେଲା ଏବେ ଅର୍ଡର ହେଇଛି ଏନୋଡ ହେଇଗଲା ଏନୋଡ ସେଟା ହେଇଗଲା ସେମାନେ କୋର୍ଟ ଯାଇଥିଲେ.
The problem is he'll give the slip. On the basis of that slip, if you write the order, tomorrow he'll come and say that it wrongly written. Nothing is there on record. पर्ची रे काम हुए.
Memo
already annex one.
That slip is gone somewhere. Thereafter you say that we'll see the record. The slip is not there.
Annexure 1, my lord.
Right. You issue write down a memo and give.
Memo कर दीजिए.
Bigger page, not some small slip. A full scrap paper and memo write down and write down in the hand.
Everything is recorded. There is no mistake.
Don't waste time right now. We understand now the case is transferred to some other court. That you want to tell that. Give a memo. At present, this case is now pending in this court right now.
NBW issue another court. Yes, sir.
This much English I can understand. Don't worry. Yes.
108 can be after petition.
Yes, yes. After 100. Yes.
110 tender for artisan machine. Oh, after
10
yes. 114.
14.
Tender for artisan age.
14 क्या भैया?
114.
1 minute. None appeals for the petitioner in the interest of justice at that. Yes.
115.
May I please, the lordship?
Yes, sir.
Now, this application is challenging the order of cognizance, my lord. This is a very peculiar case, my lord. The peculiarity is that the marriage between the petitioner and the informant was solemnized in the year 1993. Then both of them staying separately since 2001.
Opposite party has not appeared till today.
My lord, 2 times we have served the notice, and another, as per the lordship direction, we have served notice to the local IO. After brought forth this allegation, now she is disappeared.
She has initiated this case.
Yes, my lord. 17 years after the judicial separation, my lord, decree of judicial separation, she has filed and reported a FIR under section 498 of IPC. And I filed one IA with that effect. My lord, previously I filed one IA that was due to some clerical error.
Despite service of notice on opposite party number 2 through normal procedure and through the IO, the opposite party number 2 has not. Matter is urgent to so and so for hearing. In the meantime, where is the proceeding?
My lord,
where is it pending? Where is it pending?
JMFC, Leonard JMFC, Maithili.
The further proceeding in JMFC, further proceeding in which is the case number? Case number?
My lord, 203 of 2021. GR case number 203.
GR case number 203 of
2021.
21 pending in the court of
Leonard JMFC, Maithili.
Maithili. JMFC. Maithili. MATHILI. Maithili. State. Still further. Yes.
116.
Highly obliged.
Yes, sir.
114 टा
I will remove the defect within 7 days.
Yes, yes, yes. Remove the defect. I've simply adjourned. No. Yes.
116.
Nothing. None on the yes. On when the matter was taken up on 30th April 2024, none appeared for the petitioner. On that day, Mr. Maharaja pointed out that the petitioner has also not given certificates in regard to his bail application ABPL number
7376
of 2023, which has already been rejected by the court. When the matter is called up today, none appears. None appears. It seems the petitioner is not interested to proceed with the case, and so the petitioner is dismissed for non-prosecution. Yes, next.
117.
17 were taken up, my lord, after vacation.
118.
May it please your lordship.
Yes, sir.
If your lordship recollects that matter where under section 443, bail bond in respect of my property was accepted.
That matter still, what is, why you are always we are getting stuck in this matter?
OPID matter. Oh, this is relating to OPID, but your lordships had posed a query to me. Rather, your lordships had sought for a document by which the learned court below has accepted the property in question. How did he accept without verifying the property details? Now, I have got that certified copy of the order.
But in his absence, what to do? I'll take it up. Just try and bring it. I'll take it up. I mean, passing it over.
Grateful.
Yes.
119.
May it please your honor. This is the case of framing of HR under section 420 IPC.
Sir, there are some defects, sir. You have not cured. Defect number 6 and 19.
I think it is cured. No, sir, it is already done.
No, the office report is you have not cured the defect.
Sir, I have sent it by email to the AG office.
No,
We have received the copy. We have received copy, no doubt about it. For other defect,
there are 2 defects, 19 also. One defect.
Separate copy of annexure 1, 2, 1 and 2 not 5. There copy.
See, you please take care of the defects.
Yes. You know, this sent through AG has been received, no?
Yes. Mr. Chabra, counsel for the petitioner, submitted that 2 defects were cured, out of which 1 defect has already been cured. The other defects shall be cured within a week. Urgent. Yes. Next.
120.
In this matter, FIR, questioning of FIR, your lordship, the opposite party number 2 is the father-in-law of the present petitioner. Both the
opposite party number
2.
Yes.
Now, your lordship, both the daughter of the opposite party number 2 and the present petitioner, they get married and staying together. I have annexed the marriage certificate.
Where are they?
Staying in the house of the petitioner.
No, they should come here to tell that.
Made the victim as opposite party number 3 because Pooja Naik has not been made as a party.
The father of the.
I understand.
Yes.
You have to implead her also. Leave of this court to implead the victim of the case as opposite party number 3. He may do so during the course of day. To both the opposite party number 2 and 3. Okay?
2 and 3.
121.
121, may I please, my lord? May I please? Order of modification, my lord. Now, this is a petition for modification of the lordship's order dated 29/4/24.
What is the problem?
Your lordship, state is not a party at paragraph 4. Your lordship may kindly have a glance.
Private. Oh. Mr. Raghural and counsel for the state accept notice on behalf of the party. 1.
And moreover, my lord, in paragraph 5 and 7, my lord, There is opposite party number 2 has been written. It should be opposite parties.
The order dated 20/4/2024, certain mistake is the Learned Counsel for the petition points out that the state is not a party in the present case. Therefore, para 4 of the order dated 29/4/2024 shall be deleted. And in para 5, notice was only to opposite parties for 2, whereas the notice is required to be issued to all opposite parties. Accordingly, the modification application. Yes. Yes.
So also in para 7, my lord. Your lordship was pleased to issue, grant the stay subject to continuation of the payment. That is that was also written to opposite party number 2 in para
opposite in para 7 entry of opposite party number 2 opposite parties. Okay.
Requisites have been filed, my lord, which is in your lordship for both the DPO list.
Yes.
123.
Yes.
123, my lord, 498A and 506, 294 offenses are there, my lord. This is a husband-wife dispute, my lord.
Collected from the informant, my lord. Petition was submitted.
A copy may be served.
Copy
CNRH.
Copy to the sir.
I would copy it.
Yes. Give a copy in 108, yeah, 124.
124.
There are many defects, sir. 6, 13, 18, 22.
I will remove that.
Yes. Mr. Rao, the Learned Counsel for the petitioner, speaks 1 week time to cure all the defects. Pointed out the registry. 1 week time is granted. List out. Yes. Next.
125.
125 also copy may be served. Defect number 6 is there. 6 and 19.
6 and 19.
19, sir.
Copy.
6. Copy not, sir.
Yes, sir.
I will file later on
1 week time.
No, on 17th. On 17th. On 17th, in the meantime, I will solve.
17
I am not able to follow what you are saying.
On 21 hours. On 21, I will file this one.
You are chewing. You're chewing something.
His voice is like that. His voice is like that.
The voice is like that, or you chewing part? Yes.
At 21 hours.
You give a copy.
Yes, sir.
Yeah.
In course of the.
Sorry to disturb you, 118 that point of person, no OPID counsel is available. So they have requested for tomorrow. Can be
Tomorrow, do you think, do you stand a chance? Tomorrow. Let it be Monday.
My lord.
Because I don't think tomorrow will.
Monday is the case. Monday.
Because tomorrow the bar has some
Function is there.
function.
Yes.
After that, I don't think anybody will come.
Monday also there is a little chance of being.
That time, I don't know.
Let it be on Monday if your lordship can accommodate.
Hey, tomorrow also I can keep it.
No, my lord,
Subject to condition, I would come. I don't know. After lunch, I am ready to come. If you can.
Yes.
My item.
He has come now. Fine.
Well, my item be kept on 21st.
108, huh? 118.
118. He has come. Knowledge
Yes.
senior standing counsel said.
Yes, sir. What is the development in this case?
The development that I is pending, that recovery proceeding is pending, and the nothing is that nothing to opposite party number 3 is insufficient.
118.
118. There is no opposite party 3 here.
Opposite party number 2, in fact, there's a report that he is always absent. He is the main accused. So that notices were issued, yes, notices were issued, he is always absent, that is the report.
Let us serve through IO.
That will also.
You take the responsibility, you serve.
Yes, I can serve upon to approve.
In fact, they were
Standing counsel for OPID Act.
My lord, in fact, on the last occasion, they were told to take instructions regarding whether that CMC case, the civil miscellaneous case, that can be concluded, which is pending for IO's evidence only.
No, that also I'll write. Undertakes to serve opposite party number 2 through the IO of the case. And what about the instruction?
That pending, that CMC is pending.
We seeks 1 week time for seeking instruction as per the direction of this court. Which direction is that? Here. In purpose of direction of 16/4/2020. Yes.
If your lordship can call for a report from the OPID court regarding the.
That I have already called.
Yes.
Okay, we served upon for opposite party number 2.
You give a copy.
Yes. But tomorrow I'll do.
I beg pardon, my lord. In 123, my lord, I have filed for IA petition for stay, my lord. Criminal case for interim of
123.
Item number 123.
That matrimonial dispute.
Yes, my lord.
Okay, you move in 123. The same. The 123 I can notice and increase, petitioner will move application before the court for seeking adjournment. Owing to this fact.
Hello, bless.
Filed, my lord. The compromise matter, my lord. Notice go to the opposite party number 2. Already filed.
Service on the opposite party number 2 is awaited. Adjourned. Yes. ठीक है
128.
There, we can try it there once. They
You
can
try.
find a middle ground. They can go and find a middle ground there.
No,
Because the amount.
no.
Just one thing, my lord.
We were gone to mediation cell.
No. It's better to go once. I want to be settled down.
Just
She's
one
ready.
thing. We will go for mediation, my lords. I will tell the client we'll go for mediation. Just one thing. They said they have no income, but what we have said that she has income. So this financial amount on me today, I file ITR of 35,000 rupees a month. The whole of it is going towards this. So if any middle ground can be achieved, it is a win-win for all.
That can be explored in the mediation.
Yeah, that's right.
Don't put any caveat. Leave it to them.
No, I understand that, madam.
Leave it to them. Let them try. If it doesn't happen, then we'll see.
Yes, because meanwhile, my lords, what I'm given to understand is that they were proceeding with the execution. That may not be done. That is why for the execution of the orders.
You don't aggravate, ma'am. If you want to settle the dispute, don't aggravate.
Oh, okay.
Don't aggravate. That's a better idea.
My lord, actually, there the problem is going since last 2.5 years, and they are not at all paying any maintenance to me or my child. So I am going through 4 loss of execution cases in SDJ in Bhubaneswar. I'm spending a lot of money in all these cases and all, and I'm all alone. Not at all income of 1 rupee.
Subject to whatever maintenance amount is awarded, subject to they paying regularly.
No.
You go for mediation. Don't press for arrear. Whatever arrear we'll see. Only the regular maintenance you keep on paying.
Yes, yes.
And insofar as the arrear is concerned, she will not press for the time being.
Right.
And explore your possibility
Let
of
the mediation report come, my lords. Let the mediation report come. The
High Court mediation.
High Court mediation. High Court mediation, sir.
To the notice issued by this court. What is your good name, ma'am?
Kajol Tripathi.
Mrs. Kajol Tripathi is appearing in person, being opposite party number 2, and states that she is also representing the minor son.
Daughter.
Minor daughter, that is opposite party number 3. On query from the court, she says that she would be interested to explore the possibility of settlement with the petitioners, petitioners through mediation. Mr. Sibo Mishra, and counsel for the petitioner, also agrees the proposition that the proposition that the petitioners would also participate in the mediation process for exploring the possibility of a settlement. Taking into consideration the aforementioned, the parties are relegated to the High Court Mediation Center. The coordinator of the mediation center is directed to fix a date and intimate both the parties for exploration of settlement, out of court settlement. Mr. Kajol Tripathi, then opposite party number 3, submits that she is not getting any maintenance from the petitioners. Petitioner. She also says that she will not aggravate the situation by pressing
the arrears.
Execution petition, subject to condition that the petitioners shall keep on paying the regular maintenance to her.
As awarded by order dated 4/5/2022. As awarded by order dated 4/5/22.
Yes, 4/5/2022.
22.
Mr. Sibo Mishra and counsel for the petitioner submits that his clients would be making good the payment towards maintenance as directed by the court below. Wide order dated
4/5/2022.
4/5/2022. This arrangement is an interim arrangement without prejudice to right and contention of both the parties to be explored during the mediation. I am awaiting report. Please, you will be getting the interim maintenance.
They are not paying till now.
Now,
he will pay.
I have recorded their statement. He will pay. He is making that statement. Please do pay. Don't aggravate.
I will tell the client.
Immediately, you have the account number. Her account number, you said it. Do you have you given the account number?
They may give the account number or in a court also. SDGM.
No. Do you have? Do they have your account number?
No.
You furnish the account number right now. And account number, I am recording in the order. The account number, you remit their money.
Yes.
Opposite party, Kajal Tripathi is also directed to furnish the bank account number, her bank account number. Mr. Sibo Mishra submits that the regular maintenance amount shall be remitted to the account of opposite party number 2 regularly. Okay.
Yes.
Give the account number. Account number will be mentioned. Account number in the order sheet itself, account number is mentioned.
Yes.
You advise your client to remit it.
I will do that.
And try and settle the dispute.
I will tell them. The parties will attend the mediation. They will do it.
Yes. The coordinator will fix a date and intimate to both of you.
Deeply okay.
Your Honor, now the interim maintenance order by the district and session judge is given 20,000 towards the house rent accommodation and 10,000 towards our fooding.
Whatever order is there,
And,
he will keep on giving.
yeah.
Yes.
130.
I filed
Yes.
petition for modification. Your lordship's order dated 8/5/2024. Only the correction is required. That is in the first para and fourth para.
Which order? Which order?
That is 8/5/2024. That is CRLMC.
Which paragraph?
Paragraph first para and fourth para.
Hmm.
Only date that is in place of 19/3/2023. It should be written 19/3/2024. कोड़े तीन 23 जगह 24 हम और टीआर नंबर 401 जगह 4 of 2015 हम एतिकी हर करेक्शन
Where from these people got this date? I just
ना इजा the मैंने ये I have filed your lordship C that
then
is-
I am wondering where from our staff got this
number I
the
have
dates and
I have given my lord in the stated that is the copies of
have
the
you
order.
written?
I have written.
In the writ petition list of dates, it was
No, in the writ
2024. In the CRLMC.
CRLMC I have stated this 19/3/2024. Lordship
ये
C.
19 ये फर्स्ट पैराग्राफ है 19/3/2023 रहेगी 24 होगा और कौन
And TR number
TR number
4 of 2015.
102 101
ना 401 रु हम खाली 4 of 2015
खाली 4
4
2015
आ गया
2007 ଅଛି
7 is 15 हम
where from you are getting this
एटा हम एनएस करिछि सर्टिफाइड कॉपी एटा करिछि ऑर्डर कॉपी एटा ये लॉर्डशिप सी इज सेवन ए ऑर्डर कॉपी ये लॉर्डशिप एनेक्सर 2 आईआरएम करिछि ये लॉर्डशिप सी एटा पूरे से भूल एटा देइछि पूरा सर्टिफाइड कॉपी चाइटा सेटा बाप रे आईआरएम देइछि एटा रॉन्ग
yes yes
I have already stated 4 of 2015
TR number 4 of 15 ହବ ଆଉ 19/3/2023 ଜାଗାରେ 19/3/2024 ଦେଇଛି 2000 and you get the final something yes yes sorry One 31. She has been mentioned in yes.
My lords. May it please your lordship.
How much time will you take?
5 minutes only. I am appearing for the opposite party number 2 informant, my lords. And in this case,
I'm appearing for the petitioner.
Yes, what
Your
is
Lordship.
this matter?
Your Lordship, we have filed this criminal miss case challenging the criminal proceedings, Your Lordships. The present petitioners are the in-laws of the present informant.
Oh, 498.
Yes, Your Lordship.
No
We have-
scope of settlement.
Your Lordship, there have been 2 rounds of scope of settlement. My only contention is do not utilize this miss case for taking money out of the in-laws, Your Lordship. Her fight is with the husband, Your Lordship. There are series of litigations going on. She may settle the damages or whatever she is seeking for from there. Here we are only the in-laws, Your Lordship, mother-in-law, father-in-law, old and aged, and the petitioner number 3 is someone who does not even stay with them. She
No,
is
no.
the sister-in-law, Your Lordship.
Who is petitioner number 3?
Petitioner number 3 is the sister-in-law, Your Lordship.
Tehra.
Yes, Your Lordship.
sister-in-law, my lords.
Why are you after everybody?
My lord, the matter was sent for mediation and it got failed because there was no intention to settle, my lord. It was the intention only to ring. Let me complete. I have given you the, ample opportunity to submit your case. Let me.
No, no, no.
My lord, first of all,
I'm not hearing the matter as such in the marriage.
my lord, my humble submission.
You are the wife.
I am the wife. I have filed a stay of vacation of stay petition on the last occasion because the stay was granted on 25/8/2022. Since then, the opponent counsel is taking time
Your Lordship,
by
that-
citing any
that is
reason or
not
the
a
other.
fact, Your Lordship,
And-
we check the order sheet.
and so
There
far
have
as the
been
maintenance
consistent hearings. That submission is wrong.
So far as the maintenance amount is concerned, not a single pie has been paid to the petitioner wife, informant wife till date. There is an area of 3 lakh rupees. And my lord, it is also pertinent to mention here.
This is
that-
arising out of an execution.
No, your lordship.
Not arising out
Then
of.
you
We
proceed.
are
Lordship.
saying that we are using this case for the execution.
Yes, your
of
lordship may
maintenance.
see the mediation report,
No,
your
no, 1
lordship.
minute. 1 minute. Today you have moved an application for variation of
Vacation.
interim order.
Yes.
You please
Yes, your lordship.
here to me. You have moved in this application for variation of the interim order, which was passed in 2012, 2022.
22, your lordship. And your
This matter has nothing to do with your execution.
Yes.
Execution proceeding is not stayed.
No, but in the connected matter, only 40,000 rupees was, means the.
You simply answer whether execution proceeding is stayed by this court. Then you proceed with execution.
My lord.
This interim order should not bother you.
This, because of the pendency.
I'll clarify that.
Because of the stay of the criminal proceeding against all the in-laws.
Stay of criminal proceeding has nothing to do with your execution arising out of the maintenance proceedings.
Yes, your lordship, but this case doesn't hold any ground to quash the criminal proceeding.
That is a different story. What you said that because of pendency of this case, you are not getting maintenance.
I am saying that they are using delaying techniques, filing several cases one after another, and they are not paying a single file to the informant wife and just harassing her by filing several petitions. She has to appear. She doesn't have.
Your lordship, they have filed DV case. They are answering, I have only filed divorce case. They have filed DV case. They have filed 125. They have also filed this criminal case. What more is to be filed by them?
Yes, and
That's always a package. Why?
Your lordship, I am not disputing that. I am not disputing the package, your lordship. Still then.
For husband, the only option is to
Yes,
file
your
an
lordship. Your lordship,
That's
here
the
it
whole
is
difficulty.
in-laws, your lordship. She has a vendetta
No, you
against
don't
the
have case
husband.
for cancellation, variation of interim order.
No, my lord.
Main matter I'll hear.
Then it may be hard on its own merit.
Yes, I'll hear.
Yes, your lordship.
As soon as possible.
Yes.
My humble prayer.
Give a bid immediately after petition.
Much obliged, your lordship.
You can press for your execution. That's a different story. This
Another one more point. Just I would like to draw your attention, my lord, in CRLMC number 14.
why don't you advise your client to go for mediation and finish it up?
Your lordship,
We are ready for that. There is a huge.
Shall I send it to mediation?
your lordship,
Not again.
your lordship, this is what.
Let me.
Your lordship, may look into the mediation
It's
report.
all right. I'll complete the board because I have a meeting to attend. I have a meeting to attend.
Action is ahead, my lord, for that.
Yes.
Warrant was recalled. That is the wrong submission. Because of the wrong submission, that the husband is paying the maintenance regularly.
All right.
That's wrong submission.
Time will heal anything. Next time you will say that I'll settle. Yes.
My lord, I am always ready to settle. But
Your lordship,
just-
Yes, next.
the interim order may be continued, your lordship.
Entry mode will continue.
Much obliged. your
Yes.
133.
Application, my lord.
Yes. Yes. 133.
133.
Is it 430 or 445?
133.
This check 445, 430. Yes.
लिस्ट पूरा डका ହେଇଯିବ ତ
I think so. Let us see. 10 minutes I can.
ହଁ ସେଇଆ ମୁଁ ସେଇଥିପାଇଁ କହୁଛି
133.
133. So all of us are in hurry.
No, entry order there. Entry order there, one that may continue.
Urgent. Entry order to continue. Yes.
Entry order. 134.
My lord, may I will be permitted to switch on the mic.
Yes.
My lord, on the last occasion, notice was made sufficient to the opposite parties.
Do you have an interim order here?
Yes, your lordship.
Shall I vacate it?
Yes, your lordship.
Huh?
No.
Opposition not there, my lord.
Because there is no case, 420 case without any basis.
So let it be heard.
My lord, my lord. Obliged, highly
Court to
obliged.
Continue. Yes.
135.
Yes.
And there are series, so many cases, my lord. 16 cases, my lord.
That is bench matter, my lord. Your lordship decided.
Who all are appearing from other side?
opposite parties are already filed vakalatnama and the name of
And
the.
see, I have passed this order, whether all these cases are covered by that. So I'll set aside and send it back.
Except the last one, your lordship, the 4334 of 2023. ଆପଣ କରିପାରିବେନି ସେଟା। ସେଟା another organization matter. Tripura High Court.
Okay.
Oh,
Oh, I appeared in Tripura High Court. No. I recuse. That matter I recuse.
4334 of 2023, last one.
Recuse good. Okay. And all other matter, I think, on the basis of my judgment,
that is
it only has to be remanded back.
Nobody appearing, my lord,
No, already they appeared filed vakalatnama. The name are already reflected.
I'll remand it back, set aside and remand it back on the basis of the
Though paragraph number 16,
though I am appearing
17,
for the
18.
statement, some other opposite parties are there for that, my lord. They have not appeared, my lord.
Keep it tomorrow.
Tomorrow, my lord.
Keep it tomorrow.
They will not come.
This is formal order only.
My lord.
Because I am not going to pass any order. I'll just relegate them to trial court. To trial court will decide.
My lord, this is covered by your lordship.
Covered already. Yes.
Grateful.
Tomorrow, first item. Yes.
And that item may detach.
Detach refuse karo. Yes.
Grateful.
136.
Yeah. Because for that organization I appeared.
Yeah.
But one point.
Tripura Division Bench.
My lord, in this case, the husband and in-laws of the informant filed this application for quashment of the order of cognizance and enter criminal proceedings.
It needs to be heard.
My lord,
It needs to be heard.
it may be disposed of on the ground that your lordship had sent this matter to the mediation center, and your lordship can see the mediation report. Mediation has already been successful on the ground that both the parties have agreed to come for the dissolution of a marriage on mutual consent, subject to payment of 15 lakhs by the husband. And thereafter, the cases which the husband has filed and the cases
that will be withdrawn.
That will be withdrawn.
Yes.
In that light, this case may be disposed of.
Who is appearing for the?
I'm appearing for the
Yes. On the basis of mediation report, I will pass it.
This is this is both the results of the parties.
You all of you appeared before mediation center. What matrimonial?
Not necessary, my lord. I have also prepared. My God, affidavit.
Is a matrimonial dispute.
Matrimonial dispute.
Mediation on the basis of mediation report, I'll pass it.
Mediation report.
Your lordship kindly see. Kindly see.
I'll make the mediation terms of mediation as a part of the order and bound both of you to be bound by the terms and simple. Unnecessary kind of pending.
I have also
Parties are bound by the terms of the.
Certainly, they have to file a joint affidavit. That is the.
Was it a condition there?
Not necessary.
Was it a condition that parties will file?
No, no.
Your lordship was directed that both the parties to file a joint affidavit.
Where are directed?
After the report is.
Where is that direction?
There is a.
Where is that direction?
Your lordship was observed on that last occasion that you go.
Where is the direction, sir? Have I given a direction?
No direction.
The matrimonial dispute, I myself have sent it to mediation.
My lord.
You are successful mediation. I'll take it on record and pass it.
Successful. That is the report. Your lordship
Give it to me. Give it to me.
Your lordship can see the report.
Yes. Mediation report is there.
Yes.
Mediation report is there. Yes. Whatever the terms of mediation report, both the parties are bound by that.
My lord.
Yes.
Dispose of that.
Dispose of.
Like all typical in mediation reports, there is only the term is to settlement of the amount. So when that is not, nothing is there. So when
Everything is there. Your lordship.
settlement of
Everything is there.
What is this?
My learned friend is misleading this
he
court.
is not interested, my lord. Only you will linger without.
No. I am not lingering. You are lingering. You are lingering in the
After
matter.
passing of the criminal proceeding is government. You will not pay, my lord, any amount.
Professional view point ରୁ ବୋଧେ କହୁଛନ୍ତି।
If that is the case, you take.
Doubt, my lord. What
You need some other instruction from your
that is the my lord.
That you tell straight away. I'll keep it on Monday. Monday.
That the order be passed in presence of the.
एपट सेपट कहीं सीधा सीधा कोई
That is an
केस खत्म है ले मत बीच में
let-
बस काम
let-
खत्म
why
काली पे रख दो କାଲି ପାଇଁ
wife କଣ represent wife ସେଇଟା କହୁନ
why are you wasting time? I will pause it. Let him have his whatever. କାଲି ପାଇଁ ଭାଇ
ସେଇଟା କହୁନ
item 2 ରଖିବ
ଯଦି ରାଜି ହେଇଯିବ ତାଙ୍କ ଫିସ୍ ଦବା ପାଇଁ ତାହେଲେ ହେଇଯିବ ଯଦି ରାଜି ହେଇଯିବ ତାଙ୍କ ଫିସ୍ ଦବା
and professional interest has to be watched otherwise how yes another 5 minutes
145 টাকা রখি দিয়ন্ত সেটা এন্ট্রি মডেল ଥିଲା এন্ট্রি মডেল উইল কন্টিনিউ
good 45
145 of the list madam the other side has appeared matrimonial dispute
matrimonial dispute
In 145, I had appeared. Let the matter be taken up after vacation.
entry order to continue 145
in 139
yes
in 139 in view of the judgment under annexure 1 husband has been acquitted now the parents in
ଦେବ ସେଟା ତ hearing
PW ମୁଁ ଦେଇଛି entire deposition ଦେଇଛି
ଦେଖିବାକୁ ପଡିବ ନା ଏଇ deposition ପଡିବ କି ନାହିଁ
ନହେଲେ
vacation ପରେ immediate effect
139 interim order
entry mode
143
I pray for after.
interim order
143 agent
143 Lordship, I am for the opposite party
give your appearances
opposite party number 2 and Lordship matter be taken on Monday Lordship
Monday
and it is a targeted case the Hon'Ble High Court have targeted this case and trial court will conclude the trial within a period of 9 months and that is the in 2022 and that trial court has been
143
143 Monday
Tuesday ରଖିବେ yes
122 122
122 has gone now
Similar case has been posted after vacation. That is the 1200.
they are Tuesday you tell me
122, all the persons they have come from Keonjhar. I have filed 122 minutes compromise. 122.
tomorrow morning tomorrow morning it will take 5-10 minutes I will attend a meeting
Item 141, my lord. I pray for after vacation, there is an interim order, not to proceed.
Continue.
Interim order, my lord, in respect that adjournment petition, your lordship.
Interim order, the interim arrangement.
My lord, 140, my lord, 142, your lordship, I'm being covered by your lordship order, your lordship.
That has to be tested now, whether you are covered or
My
not.
91 after vacation.
Yes, yes, Mr. Pradhan.
140.
140. What do you want?
Notice was issued.
Let it be there tomorrow. I'll take it up. These 3 matters are remaining. I'll take it tomorrow.
Item 90.
Will be directed to verify as to whether opinion number 2 has appeared or not. Unless this matter.
140.
140. 140. 140.
Service position.
Yes, registry may be directed to.
My lord, item 91, Belgium matter which has disposed of, but 80 to 83 order, that is at 14 bar 2000, that has not been written.
That I know.
Item number 10 to ଆସିଛି କିନ୍ତୁ subsequent order ଟା ନହେଲେ ହବନି 14 ବାର 2000 ଟା କରେ
That only I have written.
ହଁ ଆପଣ କହିଲେ 14 ବାର 2000 item
2009 is the NBW
19
remaining matter will be
entry mode continuously and 38
in